There you go.
Make that a bit less bright. Yeah, yeah, thank you. Yeah, cheers. Display. Display settings. No, just brightness, yes. I just saw that as I clicked. Yeah. Oh, that's down here, isn't it? Oh, no, it's just. Yeah. That's it.
You'd like to do it once you've actually changed plans.
Let's see what that does. You see, it's almost completely blank. Nothing.
I wouldn't worry too much because it'll be obvious what. There's nothing on there that isn't available, is there?
No. There's no secrets. Sorry, we just tried to organise it. So that it's, well, come on, I've got to press record now. So that it's recording, which you wanted to start with, and then say that, oh, okay, apparently we are recording. It's fun. So it's going to capture what you guys are seeing on the display, but it's just, actually that's not too bad now. I don't think it's legible, but anyway. All right. Right, okay, well, sit down and strap yourselves in then as we try and get through chapters 1 to 4, which will be effectively halfway through the study guide. So I was planning to get us through to by the end of this weekend. So we've got the other half to look forward to in our next meeting. Right. I was also just, sorry, I should introduce Catherine Fuchs. I'm sure most, if not everybody in the room already knows Catherine. No? Might help, Catherine, if you guys just introduced yourselves to her.
Hello, I'm people.
And Catherine was asking me a very useful question, which I omitted to ask probably in my hysteria yesterday afternoon, which is, I think we're probably clear that none of you has any criminal experience within this jurisdiction for probably obvious reasons. But does anyone have any prior experience of slumming around the criminal? Ben's nodding.
Wasn't slumming.
Oh, sorry, top end. Yeah, right, okay. Yeah. Anybody else? Or? Yeah. Yeah. So unlikely to involve what? Having to schlep down to the police station and advise people down there, keep it zipped. Yeah. Okay.
No, I'd like to.
Was my phone off? I didn't realise. Yeah. All right. So yeah, as far as today is concerned, then in terms of topics, we're going to be basically working through, if you like, the court structure as far as the criminal justice system is concerned. Then examining effectively what happens in the various courts. Thinking, I suppose, from time to time how matters ship around between the different courts. I think Mark made the point yesterday, just saying to Catherine, about the ordinary court being almost redundant as far as criminal matters are concerned. Obviously, if Aldenians feel that they can't handle something for whatever reason, they can ship it across to the ordinary court. But although the provisions, in particular the 2008 Magistrates Court Guernsey law, do make provision for the ordinary court to exercise summary jurisdiction, which I think it's had for many years. The ordinary court doesn't hang on to these things. Certainly, when I was putting the material together for the study guide, the thing that I picked up was that the ordinary court didn't have the power to commit for trial to the Royal Court, so it would automatically send things to the Magistrates' Court for that to happen. But it would appear that the ordinary court just likes to divest itself of everything as much as possible, as quickly as possible. So there we are. Anyway, so we'll think about how things transfer around the system as well. Chapter 2. Chapter 3 gets us into thinking about bail, which is obviously important, both in terms of court bail, but also getting back to the police station, thinking about bail provisions there. And I guess also in particular things like conditional bail, what sort of conditions are available to the police, what maybe practically speaking, what do they tend to favour or disfavour in terms of attaching conditions to bail. And then chapter 4, which looks at evidence, which is, I think I said yesterday, came in for some mild comment from the adjunct that was reviewing that chapter on the basis that it was maybe babying you a bit more than the adjunct thought was appropriate, but that's fine. Quite happy and at ease with that. If there are things that are very simple, we can just zip past and get onto the more challenging areas. But anyway, so by the time we got to the end of chapter 4, we'll be, I think, just about past page 100, page 103, something like that. As I say, that's pretty much halfway through the study guide. So when we get there, frankly, it depends what happens first. You either get to the end of chapter 4 or we get to 4 o'clock, whichever comes first is when we start. Yeah. Okay, good. So any thoughts, questions, anything maybe arising from what Mark had to say yesterday, or any reading that you've done? No? All right. Can I just say, if it looks like occasionally I'm looking past you, I'm not actually kind of focused in, that's because I've got my computer glasses on so that I can see what's on the screen, which means that you're all slightly more out of focus than I would like to be the case. So if you think I'm looking at him and signalling that I want to say something, but he's just blanking me, but he looks like he's looking at me, you probably just need to say something rather than kind of raise a quizzical eyebrow in the hope that that's going to attract my attention. Because I'm looking at Ollie at the moment and I can barely see his eyebrows and whether they are, oh yeah, actually that worked. So you just got to maximise that. Good, okay. Right, so, all right, without further ado then, composition and jurisdiction. So courts that we need to think about, essentially, as far as Guernsey is concerned, obviously we've got the Magistrates' Court, and you can see we've got the Magistrates' Court Guernsey Law 2008 up on display. We might have a look through that at appropriate moments. Obviously, something that we covered for those of you that are taking the civil procedure module, we had a look at that in civil procedure before Christmas, because of course the Magistrates' Court has that kind of duality of functions. It's a criminal court, but it also functions as a civil court. What I was beginning last term to refer to as the Petty Debts Court, which is what I know it as in its kind of civil garb in Jersey. And I know I should wash my mouth up when I say that, but that's how I know it there. But I was reading something last night that I can't remember where it was now, but it definitely said that the Magistrates' Court was not to be referred to as the Petty Debts Court henceforth. That was in some enactment somewhere, so I must remove that from my vocabulary. So Magistrates' Court is just called the Magistrates' Court, whether it's acting in a criminal matter or in a civil matter. So the 2008 law covers both angles as far as that's concerned. And as you can see at 1.3 then, you can see that which court has jurisdiction will usually be determined geographically speaking, at least in the first instance. Obviously, you've got the Court of Alderney, for matters that arise there, and you've got the Court of the Seneschal in Sark. And I suppose for the sake of etiquette, I should point out that I do know that there should be plenty of accents in the word Seneschal, which frankly life was just too short for me to bother putting in. So if we just take them as being implicit every time you see Seneschal, we'll get along splendidly. So as you can see, geographically in 1.3, for the court to have jurisdiction, a substantial part of the offence has to have occurred within the relevant jurisdiction, and that should be fairly straightforward. The reference there to inchoate offences such as attempts to conspiracy, obviously they could kind of flit around geographically speaking. You can see there's a reference to a particular piece of law. I think, if I'm honest, that is the only reference in the entire study guide to that piece of law. So I'm not seeing that myself as of any major significance for our purposes. Probably at this point in time, it's appropriate for me just to say that the conversation that Catherine and I were just having there, apparently, to my astonishment, the crime rate in Alderney and Sark is not very high. So there's not much work going on there. One might take the view that that would mean that we could kind of park those two jurisdictions. I think for all sorts of reasons, we can't, frankly, do that. So whilst we might practically recognise that there's not a lot of opportunity to get the boat out to either of those islands and do something interesting, nevertheless, we need to treat them as more or less equal partners as far as the criminal justice system in the bailiwick is concerned.
Well, I think it's better than that, because one of the reasons I'm taking this course so that I can then practice on the duty register, and that involves going out to
Potentially, yes. Yeah.
Which then I can text them that, so it's very important that you do
Yes. Yes.
and it is part of our bailiwick. So
Yes. Yes. Absolutely. Yeah.
but if you're not, yeah, in order, yeah. And so the point that I was making before we started was that there's a disproportionate amount of reference in the questions. If you look at the past papers, there's nearly always something on Alderney and Sark, whereas for many practitioners, they're next separate from other jurisdictions. But yeah, absolutely, equal partners.
Okay, so let's begin with the most important of the equal partners then, which is the Magistrates' Court. So 1.4, as it says there, the governing law generally is the Magistrates' Court of Guernsey Law 2008. And yeah, jurisdictions here, all criminal matters, leaving aside the geographical issue, except the following. And I think you've got this reference, not at this particular point in the chapter, but I can see it across the page at 1.11 to THRRPP, which I tend to abbreviate in my head to kind of sound, but anyway, yeah. So treason, homicide, rape, robbery, piracy, and perjury, and all the various inchoate ways of committing those offences lie outside of the jurisdiction of the Magistrates' Court. So, in other words, if you do have any prior knowledge or you've studied kind of summary criminal proceedings in other jurisdictions, I think the Magistrates' Court here is relatively unusual in the breadth of the jurisdiction that it actually has. That's not necessarily, of course, to say that offences lying outside of that, was it sextet, I think, would just automatically be covered by the Magistrates' Court, but certainly they'd start life there, and there'd have to be a decision taken by somebody as to which was the appropriate court to then proceed with, whereas anything in those six and their inchoate associates is just going to have to go up to the Royal Court, come what may. Yeah. That's obviously something to think about. We'll be looking a bit later on at the guidance for prosecutors that the law officers in Guernsey have on their website. I did put in a couple of links, hyperlinks, or trying to anyway, to those guidance notes, or I think it's called Decision to Prosecute, and supplementary notes on Decision to Prosecute domestic violence cases. And unfortunately, it seems that the links haven't transferred through into the study guides that we have up on the VLE. It looks like they have, but in fact they're dead. So when we get to where they appear in the text, I'll give you the I'm not sure you can find them anyway, but give you the address for them. But yeah, so one of those things that a prosecutor would have to think about in terms of not just the evidential sufficiency, what charge could we go ahead with, but also things around kind of public interest, what would it be appropriate to deal with. But that's essentially one way in which the prosecution can you like, influence where the proceedings should go ahead, or where the major part of the proceedings should occur, would be in terms of making a decision, or perhaps a choice, as to what offence to actually charge somebody with. Obviously, if they choose one of these 6, then the decision about the trial venue has basically been taken before it even comes before the court. Yeah. Okay, so 1.5, very simple matter, as you can see, consistent with normal principles. It'll normally sit in open court, but it has the power to move into chambers where it considers it appropriate to do so, or indeed put people outside of the court where it's appropriate. And that might be, for example, if complainant in a perhaps particularly sensitive case, or maybe just a vulnerable complainant generally, is about to testify, and there are members of the defendant's family attending court, which would be entirely understandable from their point of view, but might be seen as making life just a little bit more difficult as far as the complainant witness is concerned. So it might be possible, without any criticism, I think, being made of anybody, but just to have individuals excluded from the court on a kind of ad hoc basis. But our general principle is it's an open court, it's a public court. And as you can see in footnote 3, whilst the juvenile court formally is a part of the magistrates' court, it, of course, like most courts dealing with juveniles and young defendants, is not of itself open to the public. So the position is flipped as far as juvenile work is concerned. Yeah. So composition 1.6, judge of the magistrates' court will sit alone. Something else that I think probably we need to flag up about that is something that Catherine was just pointing out to me, and it's not, I don't think it is in here at all, which is that the bailiff cannot sit as a judge of the magistrates' court. So deputy bailiff could do, lieutenant bailiff could do, otherwise a judge of the Royal Court could do, but not the bailiff.
Where is that? It must be written down somewhere. I don't know where it is. It's not something that comes up in the criminal context, but it comes up quite quickly. It has to be in the family context recently. Because if you have a family case running in the court, then it's nice and then you look at, you also have domestic violence injunctions. Domestic violence injunctions are in the magistrate's court. So if you've got your hearing about finances that you need your injunction, you can't do that. He has to step out and then the others come in. And we can't sit in what we shouldn't call the petty court or any other part of the magistrate's court either. I think it's a paragraph of anything for 2 that I picked up that there was a suggestion that he might be involved.
Probably.
What made it come to mind. But he personally can't be sitting in the magistrate's court.
Yeah. Okay, all right. So, yeah, I'll see if I can track down the source,
Yeah.
or it may be that there's just a lacuna somewhere, which is also going to be a bit hard to spot.
Yes, we're all trying to remember the it's maybe to do with his wife.
Okay. All right. So, as we can see, there are various criteria to qualify for appointment as a judge of the magistrates' court. Pretty straightforward, so I don't think there's much need to go through that. Usually holding office at 1.7, usually holding office until 65, but it's possible to extend that. But there's an absolute ceiling, as it says there, of 70. So restrictions about the office, so can also be a lieutenant bailiff, but cannot hold any other public office unless appointed to it by, as it says, the Crown States, Royal Court, or the bailiff. Also, perhaps unsurprisingly, forbidden from practice as a lawyer anywhere whilst they are holding that particular office. Yeah, so obviously intended, I would imagine, to avoid any issues around conflict or necessity to recuse themselves from sitting in particular cases. Although, of course, that's not a guarantee that they won't have to recuse themselves. Anyway, all right. So 1.8, deputy judges. Effectively, I guess, like an ad hoc judge, depending on the workload that the court has, and if there's something particularly significant that's working through the court. Yeah.
Because of who it was, and so that person would be
Okay, moving on to jurisdiction then. So we've already made the point about that sextet of what we might just describe as indictable only offences. But at 1.11, then for everything else, at least theoretically, the Magistrates' Court can try, take a plea, pass a sentence. And as you can see, again, I think something that cropped up yesterday in discussion with Mark, usual maxima there. So for a single offence, up to a maximum of 2 years imprisonment or a fine of twice level 5 on the uniform scale of fines. Level 5 is currently £10,000, so that would be up to £20,000. And as it says, those ceilings, if you can call them that, or maxima, can be heightened or lowered if the relevant statute provides so. And I think not at this point, but probably in chapter 5 on sentencing, because I was prompted to do so by whichever kind person reviewed chapter 5 for me. There's some reference to, I think it's the sea fishing law, which has fines of up to £50,000 in the Magistrates' Court. So yeah, so particular enactments may increase those maxima or indeed reduce them away from those. But those are your norms for a single offence, 2 years imprisonment, which again, it seems for anybody that's coming certainly from England and Wales, having studied criminal procedure there, seems quite high for a single offence, or up to £20,000 as a maximum fine. Now, you've then got aggregate provisions as well there. So you can see sentences on the same occasion for more than one offence, the Magistrates' Court could go up to 3 years. Yes.
So related to what Mark said yesterday, does that mean that these fines are per defendant, so where there are multiple defendants for the same offence? Effectively, there's 3.
Yeah.
It doesn't. The limit doesn't stop at 2 times 10. It actually.
No, that's per person.
Yeah.
Yes.
So
Yeah.
actually, it's the same offence because that was confiscation.
Yeah. I mean, I think it's a slightly different function, isn't it? Yeah. But no, I mean, it's a good point. So, but it's definitely it's per person there. As you can see, then there are some exceptions to those maxima. Rather awkwardly, it goes over the page, but 3 years, which may be exceeded if the magistrates are imposing effectively a default sentence of imprisonment. So they're actually attaching a fine. So if somebody was sentenced to, say, 3 years maximum, 3 years imprisonment for a couple of offences, and then fined, let's say, £20,000, and the magistrate decided that there should be a term of imprisonment to be served in default of payment of that £20,000, and set that period of imprisonment at 6 months, then you'd have 3.5 years rather than 3 years. But that's okay because it's a default. So in that sense, if you like, the choice whether to serve it or not is for the defendant to make. Also, if a suspended sentence is subsequently activated, so that's, I guess, seen as an example or an illustration of a more kind of general principle around suspended sentences, which is if you do re-offend during the currency of a suspended sentence, then the default setting for the new court, the sentencing court, is that both offences should be separately punished. So typically your suspended sentence, if it is activated consequent or consecutive to whatever punishment is being imposed for the new offence, for the current offence. So that's maybe just an illustration of that idea that essentially if you had a sentence of imprisonment hanging over you in suspension, that should be seen as a real disincentive, a real discouragement for reoffending. And you shouldn't basically be able to kind of reoffend with impunity, thinking, well, they'll just roll that up with whatever the new sentence is going to be. It should carry some weight and substance to it. And to an extent, the same idea is really informing C and D on that list. So if you're brought back to the magistrate's court because you failed to comply with the requirement imposed in the CSO, or if you haven't been maybe attending supervisory meetings with your probation officer, which were required as part of the probation order, then again there has to be some kind of sanction as far as that's concerned. Okay, so what else do we need to look at? We do seem to be shading somewhat into sentencing here, but since it's there, let's just have a quick look at it then. 1.12, sentences. The court has the usual power to either make them run concurrently or consecutively. And as it says there, if there were assaults on two separate victims carried out as a single incident and at the same time wrong in principle to impose consecutive sentences. And I think that's just fairly standard practice, really, so nothing particularly remarkable there. As it says, though, if the matters are totally separate and unconnected, right, that the sentences should be consecutive, subject to, again, a common principle in sentencing, which is to look at the overall picture, totality there. As it says, that in terms of aggregation for fines, there is no cap. So it's not like, well, all right, 2 times £10,000 or 2 times level 5 is the normal cap, but what could it be? Well, the answer seems to be it could be anything, essentially there. Yeah. Again, subject to looking at the overall picture. So whilst it might make sense looking at each individual offence to impose a fine up to a particular amount, and then just kind of keep doing it, when you add them all up and there's some colossal bill facing the defendant, then you might need to scale things down a little bit there. In terms of paying fines, the court has considerable flexibility as far as that's concerned. Again, there's nothing particularly unusual about it. If it forms the view that the defendant has the wherewithal to pay the fine there and then, typically that's what it will ask or demand that the defendant does. Might even be sending him out to the nearest cash point to withdraw some money.
When the judge came along and was really strict, and then the judge came along and said, "Oh, you can't keep custody. Take that man downstairs, give him a telephone, and he can get some to put the money in." There's no way to catch him from home. And so,
I remember reading a press article that said about somebody who was done for stealing from the charity box on the till, and the judge was saying, "Well, you clearly can't be sorry because you haven't even bought the money to court of the £3.50 that you stole."
Yeah, and probably make sure they bring some documentary evidence of their financial means as well.
Yeah. Unless the court knows that you have nothing, you do have a few repeat customers.
Yes. Yeah, all right. So in that respect, then pay a fine immediately or pay it within a specified period of time, quite often 14 or 28 days tends to be what magistrates like to throw out. Is it? Oh, okay.
Not a person, and then they will And so that happens. But no, sometimes it will take quite a long time.
Do you have, I know another situation there, like wage attachment orders, could you get that for this sort
Not
of
for
thing?
fines.
Not for fines, okay.
Not for fines, although I think the consultant's office would arrange that with your employer if you agree.
Yeah.
Because they're used to doing that for the
Sure, yeah. No, okay, good. Well, I'm sure we'll come back and think about that the next weekend when we move on to chapter 5 and think more generally about sentencing. But all right, so moving on to 113, then electing trial in the Royal Court. So as you can see from the footnote reference there, we're still in the 2008 law. Just to make a kind of general point here, as I think I said yesterday, I've got the 2008 law sitting there. If I think there's going to be some particular benefit from looking at a particular provision, or I've got all of the cases that we're going to be talking about in chapters 1 through to 4, just sitting here waiting to be displayed. But I'm kind of conscious that we're under a lot more time pressure because we lost those 2 hours yesterday. So I'm probably not going to be spending that much time just displaying things that you could read for yourselves. Although that was my idea, but I thought we'd have a bit more time. What I might do is see if I can just send all of the files, they're either PDFs or Word files, to Muriel to maybe put onto the VLE, so you can at least see, the case, kind of coming back to the point that Julie was making yesterday about a bibliography. So you'd have all the cases that are referred to in those chapters with highlighted passages that I think are the most important points of principle, essentially. Okay, so as it says then, an accused who is charged with an offence other than assault, but the offence itself carries a prison sentence in excess of 6 months, that individual has the right to insist on trial by the Royal Court. That right must be exercised before the accused enters a plea to the charge. And again, this is something I think that's picked up a bit later, either in this chapter or chapter 2 as well. But that is an important limitation. It has to be done before they're asked to enter a plea.
We've actually gone through the materials, but when you do, you see that it's those sort of quite particular points that get picked up. And that was one of them.
Mm. So, and you've got the wording that the court would be normally using to put the accused to that decision. Also interestingly, you can see at 1.14, HM procurer may also elect trial by the Royal Court. That's provided for in section 11 of the 2008 law. And again, that's, I would say, relatively unusual. Certainly in England and Wales, the prosecutorial involvement in which will be the trial court is normally something that is reflected, as I was saying earlier, in their decision about a choice of charge, which offence to charge, because they really, really wanted it to be, let's say, in the Royal Court. Quite often they could have chosen an indictable only offence to charge the defendant with. Obviously, that's not always going to be the case, but it's certainly something for a prosecutor to think about. Here, it would seem there's a lot more latitude given to a prosecutor to play a direct part in that. So it's not like, let's say, allocation or mode of trial proceedings in a magistrates' court in England and Wales, where realistically, having chosen the offence to charge, the only role that the prosecution would then have to play if they've chosen a triable either way offence, the only role they'd have to play would be in terms of making representations using the allocation guidelines that have been published by the Sentencing Council. Here, yeah, as it says, may elect trial by the Royal Court. So if the procurer plays that, it's like a trump card, effectively. So regardless of what the magistrate wants, regardless of what the defendant wants, if the procurator says, right, I want this to go to the Royal Court to be tried there, that's what's going to happen. No ifs, buts, or maybes about that. So in terms of committal for trial, 1.15, you can see then, cases can be sent for trial to the Royal Court. So either through election, which we were just looking at, from prosecution or defence, or charging an indictable only offence, or if the magistrate or judge of the magistrates court declines jurisdiction. And that could be for a number of different, two different factors, which are explored in that paragraph at 115. So either it feels that judge feels that their sentencing powers are insufficient to deal with the offence, or due to the gravity of the matter, that it's more appropriate to proceed in the Royal Court. And this is the sort of thing I think that Mark was alluding to yesterday in terms of things like drug trafficking, or just supplying, dealing in drugs, something that usually the Magistrates Court would just send up to the Royal Court for matters to proceed there. Fairly obviously, if you've looked at the Richards case, which is the guideline sentencing case on drug dealing in this jurisdiction, pretty much any of the sentences, even the lowest sentence there, I think is on the borderline, if not actually above what the Magistrates Court could impose. So, yeah.
Tensions between the Magistrates Court and the Royal Court. So I had a case in the Magistrates Court, not I think it was in 2017, where he was charged with possession, but not in possession with intent to supply, quite a reasonable chunk of cannabis. And there was a certain amount of argument about whether that should be dealt with. And the magistrate effectively said that he was sending it up to the Royal Court because he was concerned about consistency powers, because it's the quantity. And he invited the Royal Court to issue guidelines as to what to do with these chunks of drugs, which, if the world has changed a little bit, I know that. The Richards guidelines came out when people were importing very large quantities of cannabis into the underground box and in car boots and various other ways. And it was fairly obvious what was the Magistrates Court and what was the Royal Court. What we're now getting are it's a different pattern. So we've got, for example, the likes of Mr. Hone, who explained to the court in open court, who knew that it was this for medicinal use, and he wasn't saying it to other people in the prosecution happily accepted that. But it was a quantity that the magistrate didn't feel comfortable in dealing with. So he used his power to send it upstairs. He didn't get the guidelines because the Royal Court declined to give him guidelines. Different sort of problem we're now having are cases coming through, and I just had one in the Royal Court, Hammond and Archer, who were prosecuted for possessing quantities of cannabis. In the case of Hammond, actually very small quantity of cannabis, he had a few grams in his pocket that he was about to deliver, and so that was with intent to supply. And then he also had a couple of small quantities on a separate account. And he got quite a long sentence because he had previous conviction for slightly bigger amount of use, also reach or abuse for services. But it raises questions about the box here. But there's a cultural, there is a little bit of a cultural shift because now so the court there is looking very much at the Texas that we're going on, lots of people Texans saying we've got this, we've got that, using these kind of words and learning other words they use to try and figure out what they're dealing with. And the court imposed a sentence with most of the appeals, so it's a bit fancy part, and the sentencing exercise is very difficult. But the court does exercise its power to send the matter upstairs. Just going back to something Rob said a moment ago about the possibility that the court would elect or be involved in a decision that the magistrate would send the matter up to the Royal Court. I have seen the prosecution on one occasion where a matter was a magistrate court matter. I'm not tribal either way. Engage in conversation with the magistrate as to whether it should go upstairs to send because the prosecutor felt that the sentencing had been not adequate. So if there gets into a discussion, then the prosecutor will input it.
Okay.
And what's the right of being accused in that? Well, and the convicted in that case? None.
The right.
As in, do you get to be part of that?
Oh,
discussion?
absolutely. So, I mean, I was making my own. Wasn't easy upstairs because blah blah. But it was one of the three discussions that prosecutor and defence.
And in terms of your feeling, is there an indication as to what does it depend on the particular facts of the case, or is there an overarching?
Oh, I think it's usually very clear from the outset.
But that's different than an election made by the prosecutor. I mean, the prosecutor could have just said, well, I like things up.
Well, it wasn't a trial.
I'll say,
And was it sent up?
Hmm?
Was it sent up?
I don't know the discussion. I don't know. I think so.
All right, I've just changed, partly because I was getting bored with looking at it, from the first page of the Magistrates 2008 law to essentially the text that I've cribbed from 1995 Guernsey Law Journal, the case of Haynes, which I've referenced at 1.15 in the study guide. Just because of a couple of points that paragraph 115 picks up then. So as you can see, this is the Court of Appeal in this case. Said the responsibility of selecting the court of trial rests with the prosecution. And I guess to that extent, it's correct in coming back to their choice of charge, essentially. I don't think you can take it any further than that, because it does seem to be a very open statement that the Court of Appeal is making there. And it may just be this was a wacky Court of Appeal. I don't know. You can see, open to the magistrate to commit the defendant for sentence, where he considers his powers to be insufficient, which is what Catherine was just talking about. Now you can see in the text at 1.15, says there is no explicit power to commit for sentence given by the 2008 law. Now, as you can see, it seems, what I've said there is, it seems this was said in error. That's as a result of the discussion I had. I can't remember who the adjunct was that reviewed this chapter, but the discussion I had with the adjunct, Bleshing, who took the view that there wasn't power to commit for sentence. Okay, and that's why you've got that point made in footnote 30, that whoever is reporting on this for the Guernsey Law Journal may have misunderstood or misheard, or just misnoted what was being said there, and what the Court of Appeal either actually said or intended to say was it was open to the magistrate to commit a defendant for trial if he considers his powers to be insufficient, which I think we all agree is perfectly possible for the magistrate to do. So, but since we've just heard from Catherine that magistrates do, at least from time to time, commit for sentence, then yeah, maybe the Court of Appeal wasn't quite as misunderstood or misunderstanding itself as that text suggests at 1.15. Yeah. Yeah, I can't remember who the adjunct was that looked at each of the individual chapters, but anyway. So it may be there's a power, if there isn't an explicit power in the 2008 law, I think that I'd agree with that, but there may be something somewhere else. So anyway, what's going to happen in the committee for trial, 1.16 then, magistrate will receive the written evidence of the witnesses to determine whether or not there's a case to answer. We only need a prima facie case, which is called standard, as far as a committal for trial is concerned. So the court, the judge in the magistrate's court, is not concerning themselves with is the accused guilty or not guilty. as long as the prosecution evidence that's tendered shows a prima facie case, then he's going to be committed for trial. 1.17 takes us on to thinking about what we might describe as a slip rule. So where the magistrate can be persuaded that he or she has done something that they shouldn't have done, perhaps done it in a way that they shouldn't have done it, then they can effectively take it back. You don't need to appeal to the Royal Court necessarily. So as you can see, Magistrates' Court has the power to quash a conviction that it has imposed and either vary or rescind a sentence or other type of order that doesn't technically fall to be described as a sentence, but one that it made when it was dealing with an offender. And that's a power that it can use any time it considers it in the interest of justice to do that. So as you can see at 1.17, if it does reopen sentencing, then it can substitute any other sentence or order that it has the power to impose. Again, significant point here, the ability to use that slip rule jurisdiction is lost if the defendant has appealed to the Royal Court, either against the conviction on which the sentence was based, or the sentence or other order. Okay, so an appeal to the Royal Court will mean that you can't then turn to the Magistrates' Court and say, well, would you reconsider that because you've acted in excess of jurisdiction, or whatever it happens to have been. 1.18, effectively, applying the slip rule, the magistrate could order a retrial in front of a different tribunal, so obviously still the Magistrates' Court, but a different judge sitting. And again, that ability will be lost if the offender has already appealed to the Royal Court. If it appears, as it says 1.19, that the defendant ought not to be convicted by the Magistrates' Court, then that conviction could be quashed by the Royal Court, and the application will be made effectively in the public interest as a Minister of Justice by HM Procurer. And that might be the sort of thing where perhaps proceedings had been brought under either a law that hadn't actually taken effect at the date when the offence was allegedly committed, or perhaps had been repealed at the date that the offence had allegedly been committed. So you've either been preemptively convicted when you shouldn't have been, or retrospectively convicted when you shouldn't have been. But obviously, yes, that's the sort of thing that should be obvious on the face of the legal framework, and that's why it's really in the hands of the procurer to make that application. Well, it shouldn't do, should it?
I'm not, I must admit, I'm really interested. Can I just say that
Sorry, okay, I'm emphasising the wrong syllable. Okay, all right.
Because if any of this
All right, that's very important to show that you can talk the talk. Yes, good. All right, so just to round things up, as you can see at 1.20, under the 2008 law, the Magistrates' Court also has the jurisdiction to hold inquests, but as far as I'm concerned, that is beyond our remit to worry about. So I don't know if it's coming up anywhere else, but it's not coming up here, as far as I'm concerned. No, no. Okay, I mean, I think it might be worthwhile just to know that it has the jurisdiction. And, you know, if you're going to have an inquest, that's where it's going to be, but that's the sum total of it.
Well, there have been a couple of there have been some interesting cases recently. I had an inquest which was reported in the paper where the judge declined to hold that he had killed himself because she was not satisfied that he'd intended to do so. So that was quite a lot of technical law on that one. And we've got one coming up that starts on Monday, one of the baby death ones is coming up, because we don't have the infrastructure that we have in England to do with inquests. I don't believe it's part of the syllabus.
No.
But there was that case. there's not an awful lot of learning on it to read.
Okay, all right. So moving away from the Magistrates' Court itself, then to the Court of Alderney, we leave the 2008 law behind. We now need to have a look at the Government of Alderney law. And as you can see there, the full Court of Alderney is a chairman and 2 or more jurats. Generally, the chairman is a jurat, and they will decide both questions of fact, which of course is their normal province that we're used to as far as Guernsey is concerned, but they'll also be deciding questions of law because there's nobody else there to be doing that. As it says, the chair doesn't usually have a vote unless there's an equal division amongst the jurats or the other jurats, and they'll have a casting vote. Again, 1.22 takes you through things about holding office, not sitting. Again, conflict point, jurat may not sit when the court is dealing with any matter in which he has a personal interest. And as I've noted there, that's just a general rule of natural justice, that you shouldn't be a judge in your own cause, but it's also specifically provided for in the 2004 law. There's another specific provision there in terms of licensed undertakings, not sitting when those sorts of matters are being dealt with before the court. And as you can see, it may be that if we're kind of rapidly running out of jurats to actually sit on a particular matter, such that the court won't be able to be quorate to deal with that particular case, application to be made to the bailiff here to appoint someone to exercise the court's powers in that connection. So is there anything else we need to say as far as that's concerned? You've got your greffier there.
Who is normally, and I think you.
Greffier, yeah.
Because there's a part of the court, so I don't know how the lawyers in there. It would be an interesting tribunal.
Well, that's something that has come up perhaps in other contexts, really, isn't it? But particularly perhaps with regard to SARC. Yes. But yes, somebody needs to know what they're doing, legally speaking. Yes. All right. So 124. Criminal proceedings in Alderney can only be commenced by or under the authority of the procurer. Was that better? Okay. And the same kind of limitation then, that sextet of offences, the Court of Alderney does not have jurisdiction to try. It will simply look to see whether there's a prima facie case made out or not, and if it considers that there is, then the matter will be transferred to the ordinary court in Guernsey, where it, as we know, it will then be bounced straight off to the magistrates' court. In terms of sentencing powers, 1.25, if we're looking at a single offence, maximum in Alderney is 12 months imprisonment and or a fine up to level 5 on the uniform scale. And it's probably worth pointing out at this stage that Guernsey and Alderney and Sark each have their own independent uniform scales. So you just need to make sure that you're looking at the right one. So as you can see, level fine there, a level 5 fine is £10,000. In terms of aggregation, if you've got several offences, the maximum is still capped at 12 months. Okay, but for a fine, it's gone up to 2 times level 5. So if you're looking at multiple offences, it makes no difference if the court's talking about imprisonment, but it could make quite a significant difference if the court was talking about a fine. And again, I suppose that's potentially an interesting point of difference between what would happen in the Court of Alderney as compared to what would happen with the Magistrates' Court here. So again, the sort of thing that potentially, I suppose, could form part of an exam question. So as it says, if the likely sentence is seen as falling below those thresholds, the court in Alderney will deal with the matter. If it thinks that those maxima are likely to be exceeded and there's a prima facie case, then it will transfer the matter to the ordinary court. You'll note the defendant in Alderney has no express right to elect a trial in the Royal Court, but if the matter is transferred to the ordinary court, then of course he can just follow the usual proceedings and elects trial, assuming that it's an imprisonable offence carrying at least 6 months. And not the sort of, I mean, did you have any thoughts about why assault is kind of excluded? I mean, I couldn't think of any particular rationale behind it, but no, that's what it says. Yeah, okay. Yeah, as is lots of reason why. No, okay. And as you can see, a dissatisfied or disgruntled defendant can appeal from a decision, either a conviction or a sentence, imposed by the Court of Alderney to the full court of the Royal Court. So there's much else to pick out from the footnotes there. Maybe from footnote 49, if the Court of Alderney does impose a prison sentence, that would usually be served at the prison here in Guernsey. I don't know what prison facilities are like on Alderney, but you probably wouldn't spend too long in them. But, you know. No, go for the much more luxurious setup here. Yes. Okay. Good. SARC then, 1.28. Again, we shift enactments, so we're now looking at the reformed SARC law 2008. It says, as amended. It does need to be amended quite a lot for all sorts of reasons, but yeah. Yes. So as you can see, then the judge in the court is the seneschal, but they could have a deputy seneschal or a lieutenant seneschal. No jurats are involved, so they are sitting alone there, and therefore, of necessity, they are determining all issues, whether factual or legal. As it says, it's not a requirement that they are legally qualified. So again, that's a point of distinction with, say, the Magistrates' Court here in Guernsey. And as I think those of you that were taking the civil module last term will be aware, there are various cases. I think, is it Leonard? I think it's Leonard and Ruat is one of those cases. And also, I think there's cases involving the Carteret, unless everybody on SARC is called the Carteret. Yeah, at least 2 discrete cases, as far as I can see, involving people called the Carteret on SARC, that make the point that the nature of the court is such that advocates owe a particularly raised level of obligation to the court to, I think, be proactive and to assist it to make sure that it's got the correct legal framework for its decisions and it's applying them in a correct or legally valid fashion. So it's one of those situations where I think essentially it's not, a little bit like in England and Wales these days, where you're not, when I was a lad, you could just sit there and go, you've got that wrong, note of that, so that's another ground of appeal. Thank you very much. Good, well done. Keep going. Keep the mistakes coming. You're not supposed to do that anymore, particularly somewhere like SARC, where the court isn't legally qualified. And it may well be, as it says, the seneschal sits with the greffier. I don't think there's a requirement in SARC that the greffier is legally qualified either. So the only people who are legally qualified will probably be the advocates, if they're represented, yes.
Because that's something that permeates through all of the different options.
You need to the SARC court specifically.
No, you can't just, as we're prison, you can't just sit there and let the court make a mess of it and then appeal. And it's an interesting, there are lots of nuances there, but that's the general view is that but it's very clear. To the court is great and really to the client.
Yes, something that clients tend not to be very appreciative.
No, certainly not. But that's the way it is. It's certainly
yes.
are on the side of caution.
Can require sensitive handling. Yes.
But there is a letter. There is my partner, who is a lawyer, and so when they have anything that's complex, and he's going to sit over there and find that, and then he goes across. So he
Yeah, I mean, if we look at,
So they don't do it, they don't do it with any kind of anything usually. They have a fairly robust screening system.
yes, if we look at, I mean, you can see in 128, there's a reference there to a deputy or a lieutenant seneschal. And if we look at footnote 54, you can see for appointment as a lieutenant seneschal, the criteria are the same as those for appointment as a judge at the magistrates' court in Guernsey. So lieutenant seneschal will be has to be legally qualified in order for that appointment to be made in the first place. Okay. What else do we need to think about? I think, well, 1.29 again is technical points. You can see there the expected retirement age is the 65th birthday, can be reappointed for subsequent periods not exceeding 5 years, but there's an overall ceiling there attained to the age of 75. So again, that's a difference, because it was 70 as far as the judge of the magistrates' court is concerned. 1.30 in terms of their jurisdiction over different offences, it's the same as we've already looked at with Alderley and with Guernsey then. So that's set the usual sextet, the THRRPP offences. The Court of the Seneschal has no jurisdiction over. Criminal proceedings can only be commenced, again as per Alderley, by or with the authority of the procurer. 131. The basic sentencing maxima. So single offence, a month's imprisonment. So again, significantly different to what we've seen before. So the three courts have different maxima as far as custodial sentences are concerned, or a fine up to level 4 on the uniform scale, which would be £5,000 in this context. Where you have multiple offences, then the aggregates go up to what? 2 months imprisonment and twice the level 4 fine. Any term of imprisonment beyond 3 days, you'll be shipped across to Guernsey. 132, transferring the matter. So as it says, if the court considers that the offence or its likely punishment are beyond their competence to deal with, then it will be transferred to the ordinary court. Interestingly, that will happen automatically without the need for the prosecution to establish a prima facie case. Okay? So they won't even go that far. And again, fines at level 5 fall outside the jurisdiction of the court itself. So if it felt that a fine at level 5, which would be somewhere above £5,000 but less than £10,000, was going to be appropriate, then they would consequently ship the matter across to the ordinary court. Again, 133, there's a right of appeal to the Royal Court sitting as full court. There'll be a greffier. Enforcing court judgments, collecting fines is done by the Prévôt. Prévôt, yes? Okay, good. And as you can see, I've thrown in there something from the Reformed SARC law, section 4.3. Customary law in criminal matters in SARC is the same as it is in Guernsey. Now, I said it because that's what section 4 sub 3 says, but it sounds rather cryptic to me looking back at it now, and it's going to stay cryptic as well. That's as much detail as I could put on that. The customary law is the same in SARC as it is in Guernsey, and beyond that, all is darkness. So there we are. A lot of criminal law is customary law still, isn't it? I mean, do we need to kind of delve into that in more detail?
I was wondering about that. The trouble is, it's such a nebulous.
Yeah.
You already know it's customary if you come across it, and you have to explore it. Things like assault. I mean, what I would say is that elderly copies of art law can be very useful, and in the many DeCock hearings, one of the points that came up, I can't remember which one it was, required us to find Mr. Randall's 1948 copy of Archbold and had me on the phone to the people that scan across the relevant sections of very old art laws, the common law, which was effectively the same as the customary law. So, yeah, there
Well, in a way, that's very similar to, what is it, we're not looking at it today, but the round of appeal against conviction, which is still based on, I think, the 1907 Criminal Appeal Act, which is long gone back in England and Wales. But, yeah.
I mean, as a citizen, if you're looking, I think you can look at legislation, if you're looking at disability legislation, which is not keeping pace with English legislation, and the modern article in Baxter, you have to go back to the edition that was dealing with the English law at the point where they passed it. It's obvious, but people quite often might think to do it. And there's a wealth of learning because the case law in England at the time before they introduced the new statute would be extensive case law on the point of innocence.
Yeah. No matter how archaic it may seem.
Well, exactly, and none of the reporting uses its power to develop well, the name of the one for the negligence. Yes, more than that. So it will use its ability to develop its law as necessary in but it's a problem where our legislation is quite often copied wholesale, but then it's suddenly won't. And the differences between the Guernsey and the Guernsey legislation and English legislation are often very important. Good to get back.
Yeah, I mean, something that we'll look at in the course of today, hopefully, in chapter 4 will be issues around bad character evidence for the defendant. And that underwent massive revision in 2003-4 in England and Wales in the Criminal Justice Act of 2003, came into effect in January 2004. But the defendant bad character provisions, as far as this jurisdiction is concerned, are still those that I used to know and love from what was the Criminal Evidence Act of 1898. Things have not moved on. So, yeah, old, as Catherine says, old textbooks can be very valuable. I think certainly in Jersey, things might be changing now because they're kind of reconfiguring their approach to civil litigation over there. But up until very recently, probably still actually going on today, I think they're still having specially printed editions of the 1999 White Book because it's got the stuff that predates the civil procedure rules in. Yeah. Okay, all right. Well, I'll tell you what, we'll just do the little section on the ordinary court, take ourselves up to the Royal Court, and then we'll have a, 10-minute break? Yeah, okay. So, as you can see then, the ordinary court, relevant law, we're back to the 2008 Max Court law, and the ordinary court can exercise the original summary jurisdiction of criminal matters that have arisen in Alderney or Sark, and as it says, whether the crime was committed there, or if the accused, or if there are more than one of them at least is resident in Alderney or Sark. And you can see then again that the respective courts may in fact send cases to the ordinary court, and that will be the bailiff or deputy bailiff, I think, and the lieutenant bailiff, although I haven't included that, sitting without jurats. So 137, when a case does come before the ordinary court, that court has the same jurisdiction and powers of sentence as the magistrates' court would do, but from what we have now learned, or from what I've learned, it's not going to exercise those powers. It's just going to wave them through to the magistrates' court. You can see it expressly has powers, and in the circumstance, although this would be tempting to say it could be a nice exam point, I think because of the lack of practicality of it, it's not going to be an exam point if I've got anything to do with it, is the fact that the ordinary court cannot commit for trial to the Royal Court, since it's not doing anything anyway, not conducting trials or anything else, just transferring things to the magistrates' court. I think we can probably just kiss goodbye to that otherwise interesting point.
I don't know. I think it's the sort of thing we need to welcome up and it was, as people always do in that, they want to know what's going to happen. And so they're expecting to answer their questions in the police station. Can I go outside for a fan? And the answer which is no. To what my sentence is basically. And along the way, how will it work? What will the process? So it's good. I think it's an interesting point, and it's a good point. If you happen to be doing with engineers, like, you know, what's going to happen to them, where course they're going to end up in. And it's no bad thing along the way to note that if it's a very serious matter, it's pathway through to the Royal Court.
And does that mean, going to the person's point, that if the ordinary court, the bailiff sits, and it can have the same jurisdiction as the magistrate's court, in theory, the bailiff could sit as the magistrate's court.
He can't sit as a magistrate.
So why does it say here?
It has the same powers.
And the court would open, he would sit as the ordinary court, and he would say, I am transferring this case to the magistrate's court.
But it allows him to actually express this, to actually exercise the powers that the magistrate's
Yeah,
court.
but if I'm sitting as a law court judge and I'm exercising my powers, that means that the things that I can do are what a magistrate can do, it's not like a magistrate.
I found that really strange to understand and why you can't have the bailiff doing it, as in sitting in the magistrate's court. If
You just
Right.
got to sit as a
I think
magistrate.
that's getting us back into the question that we couldn't resolve before, which is if we can find the source, then we probably have a better idea. Yeah. Right, so it's just coming up, well, it's just gone 25 past. So should we adjourn now and come back at 25 to? Go and make a cup of tea or coffee? I don't know what the position is financially with that. I see
Well, I think
Catherine's sensory bought her flights.
I was tipped around.
Yeah, I should have said something to you, but yes. It's been a very significant bone of contention.
That's how I gather, so I maybe I'm getting coffee and.
Right.
No. I will do a little bit of research.
These biscuits will go off. So we should,
I will find out. But I don't think that's an issue. I mean, I think you have
Yeah.
to sit in. The reality, you just means that there's no control.
mid-afternoon.
Yes.
You can't do what perhaps one of the others do. which is, here I am, judge of the order.
Yes,
And
yes.
that's going to magistrate court.
And it's me again, everyone.
Here I am. We've reconstituted, and this is what they do, they'll say, right, we
Yes,
and
yes.
we're reconstituting the court. Now what are we going to do? Okay, you need to do legal advice.
Yeah.
You failed, whatever it is. And
Yeah.
so that's actually what happens. The thing about the lieutenant bailiff is that I believe that all of the judges of the Royal Court, etc., they're all lieutenant bailiffs.
Mm.
Because this thing about judge of the Royal Court is a very modern thing.
Yeah.
Prior to that, all subsidiary judges
Yes.
were called lieutenant
Yes.
bailiffs. And if you go back to when I qualified, the jurists were also, and some of them are still lieutenant bailiffs,
Uh-huh.
and they actually sat as magistrates.
Right. Interesting.
With interesting,
Yeah.
it's one of my anecdotes where I made my submission of no case once. And I was too junior to realise that that was the point at which I should have accused him. But anyway, the unqualified,
Yeah,
called him out, and we carried on, and he found him not guilty, and on we've gone through the rest of the trial. But of course, I should have accused him. I was
Yeah,
just so
yeah.
gobsmacked.
Well, I think there was a letter in the Times this week, somebody reminiscing about the magistrates' court. I don't know what's sparked the correspondence, but yeah, somebody's reminiscing from like years ago. They were appearing in the magistrates' court, and there were a lot of, it was kind of multi-handed thing, and a lot of defence lawyers all sitting there present and correct when the magistrates walked in, but the prosecutor wasn't there. And apparently the chairman of the bench leaned forward to Clark and said, "Where's our fella then?" Which point somebody made an application.
Yeah. By the way, it's been interesting.
Right, okay.
I think that's correct in the last 3 years.
Recusal, yeah.
I don't like that.
Okay.
This is a recusal.
Mhm.
You want a coffee?
No, I'm fine, thank you.
you want to share now?
I don't know, sorry.
We can bring in our own tea bags.
Yeah.
I do think.
But they even close the tea box now. Big one.
Really?
Yeah.
All right. Is the biscuit box still there?
No.
No. Wow.
So we have to sneak into the actual kitchen to get the box.
Yeah.
Not the biscuits, the whole.
No. Imagine that they actually shut the or locked the kitchen door.
Oh,
They have to start bringing a kettle then. When I say we, I mean you. No, they couldn't do that because Kate has said to me that I am entitled to free tea and coffee.
So that works out who actually benefits.
Yeah, yeah, if I wanted to.
If you want.
Yeah. So really what I should do is just decide that I suddenly want 6 cups of coffee. Yes.
So there's another session in a fortnight,
Yes.
and then there's another one in April.
That will be a revision one. Because presumably by that point, well, I'd like to think by that point, we'll have a reasonable idea of the kind of basic scope of the exam
There
paper.
ought to be some sort of sample paper then, surely.
Well,
Because that's- But then you, well, they haven't decided if we to say perhaps that in the position I'm saying, we either need to know that the old papers are a good basis for us to look at in terms of what structure and format might be and scope, or they need to issue something. Maybe reports on some first got to GCSEs in England, and under the new system, you have to, we'll give them at least one sample.
It's so much we have to make up this point, and he said that there cannot be a complete breach with previous years that happened. So my understanding is that there will be.
Then your papers are useful.
That was my understanding of what he said, but
And I think
unless you go off the record.
there are some fun points in those papers. There are some things which I wouldn't know how to talk to my colleagues about because I don't know the answers. But that's often deliberate. There's usually a question on every paper, isn't it? And it's because they don't see any reason. It often doesn't have an answer. What you also see in your papers are scenarios that come up and repeat issues and maybe there's no reported present in the end. So it's to do with your ability to reason and follow resources that are well known, not necessarily your knowledge of science or equipment. But there was one of the things I feel better. So,
No, I think that's not necessarily that unusual for an
No,
exam
no.
paper that there'll be a question or two in there that are looking really how are you going to navigate your way through this. There's not necessarily a single right answer destination you're expected to get to. It's how you would think about it. Yeah.
which stages you go to, I mean, starting at the beginning, to make sure people always start at the beginning, look at the charge, you know, look at the jurisdiction, that's why those things are actually really important, you know, making sure that you don't accidentally add something to, you know, the main magistrate.
Yeah. I think she called Sue, whoever the lady was that was replacing Kate this morning, did say she's going to turn the heating up.
Well, it's set to 22 degrees, which is.
That's pretty tropical, isn't it?
I don't know, it was 29 degrees in Florida for New Year's, so I've been back there.
It's just 24 degrees.
Yeah.
And the room is currently at 18. It's a lot colder than 18.
It's a little snowflake.
It's got a little wind chill in here.
One of these snowflakes.
No, in the display.
I just put the thing on. So it might be less
Ah. See, the British Army is now recruiting snowflakes.
Yeah.
Yeah. Was it, we want you for your compassion? I think that was it. Right, we'll just wait for Catherine to return and then start. I think I either need to be saying less or saying it faster because we've still got 90 pages to go.
So as a learning point so far, we've only come across 2 courses, but claims, you just keep telling us this, the Garys and the claims, which are basically all the cases. Can you continue to tell us when you need to get a case?
Well, as I say, I mean, you can see here, this is my list of laws and cases from the first 4 chapters. I mean, there's not that much, really.
Well, so I went through and got all the cases.
Yeah.
There's over 130.
From the whole
From the
thing,
whole
yeah.
thing. And there's only statutes, over 60
Mm.
in terms of laws. It would just be helpful to have an idea. Because I mean, statutes, but a case, if you start using all of them, you'll be there for a long time.
Yeah. Well, I mean,
And I know we're supposed to do cases, it's important to do, but
yeah. Well, that's to say, that's why with the ones that I've got there might be 1 or 2 exceptions where just technically I couldn't get the thing to work. But generally, as you'll have seen with the Haynes case, I've just highlighted what I think are the important passages within each case. So I'll see if I can somehow send these to Muriel to just get that lot put onto the VLE. So you can look through them. Yes, both from a practitioner point of view and an educational point of view, yes, I agree. And I would always say to people, it's important to go back and read the entire case to see the context within which the conversation is taking place. But I appreciate that you guys have got a number of modules to be doing that with. So maybe the time just isn't there to do that, or not with everything anyway. Some cases, I guess, almost self-evidently, it will be more important to do that, perhaps because of the number of times they recur. Right, okay. So the Royal Court. Let's commence again. So 1.38. This is the Royal Court sitting as the full court, or the Cour Hall. And as you can see then, it will be dealing with matters that are within its specific jurisdiction, exclusive jurisdiction, so as THRRPP cases, or those where an election has been made either by the procurer or by the defendant, or where the magistrate has decided that it needs to go to the Royal Court. So who's going to be sitting? As it says, the bailiff will be the presiding judge, but can be replaced either by deputy bailiff, lieutenant bailiff, or a judge of the Royal Court. You will note there that a judge of the Royal Court can preside over the Royal Court and carry out any judicial function of the office of bailiff, but cannot sit in the Court of Appeal and cannot appoint lieutenant bailiffs. So there are certain limitations on what they can do. and Catherine was just saying to me, I think before, during the break, that judges, someone appointment as a judge of the Royal Court is a relatively new matter, whereas one would have lieutenant bailiffs, there seem to be people these days who are just appointed as a judge of the Royal Court, that they will have those limitations, so they won't be sitting in the Court of Appeal. So as we can see then, judge of the Royal Court may constitute the Magistrates' Court and have all the functions of the judge of the Magistrates' Court. I don't think there's anything else that we need to think about in there. Obviously, if there are questions of law, then the bailiff on their own will quite properly constitute the court. So you can see, for example, sitting to take the pleas of the defendant to the indictment, or hear any application made as to admissibility of confession evidence or exclusion of prosecution evidence. Those will be matters of law. So the bailiff, or whoever's sitting in the place of the bailiff, will decide those matters sitting alone without the jurats being present, apart from the fact that it's not their decision to make. Obviously, one would want to avoid any kind of contamination where they hear about something which then gets ruled as inadmissible.
Often with a certain background, so you can see them applications, but they're cheap now when they're needed.
I mean, it is an interesting point, because, of course, a judge would say, well, it's all right, counsel, because I can maintain that distinction between what I'm allowed to know for the purpose of making a decision and the things I can put out of my mind. But in this sense, jurats are treated differently, like jurors are, treated differently as I think it's not so much that anybody thinks they're incapable of maintaining that distinction. I think it's for the appearance of justice being seen to be done.
Yes. Yeah. And we in Guernsey particularly are not allowed to say that there are distinctions because of material. I have to say, I agree with that sentiment.
Yeah. Yes. All right. So questions of fact then. So verdict, guilty, not guilty, sentence. They are matters for obviously for the jurats to be involved with. And as you can see then, it says there you need at least 7 to be quorate. You'll often have 9. You don't really want an even number to be sitting, because that could end up with a school draw, which is not good for anybody, really. But as you can see then, if you do have, maybe for some reason someone's fallen ill and is no longer able to sit, then there may be an even number. They may divide equally, and if so, the bailiff has the casting vote. Although I think I'm right in saying it's not something that I think I've dealt with in the study guide. But whereas in Jersey, the bailiff is entitled to retire with the jurats there, that's not the position.
That's my understanding.
Yeah.
It doesn't become a thing for the third.
So, as you can see, they're just procedurally where they are reaching a verdict on convicting or not. You can see the senior jurat who's sitting in the matter will state in open court, jurats have found the accused either guilty, not guilty, or not guilty by reason of insanity, which is still a legitimate verdict here. So if it's a guilty verdict, senior jurat states whether the verdict was unanimous or by a majority, and where it was a majority verdict will indicate how they were split there. Again, if the verdict is not guilty, then I think the same as in England and Wales, the jurats are not expected to divulge. If it's certainly they should be expected to divulge no, let me rephrase that. They are not expected to divulge whether it's unanimous or majority decision, because you don't want different classes of acquittal. Everybody agreed that I was innocent, but only 5 of them agreed that you were innocent. So clearly you're a lot guiltier than I am. Yeah. So okay, you don't interrogate. Excuse me, don't interrogate jurors. Well, it's a not guilty verdict. Excuse me. So sentencing then, 1.42. Bailiff and jurats will confer together to determine the sentence. As it says, unless it's one that's fixed by law, which would be relatively unusual. Typical example that one would offer there would be for homicide, where you'd be looking at life imprisonment. But generally speaking, of course, the court has a lot of flexibility in terms of sentence. And here, then, the bailiff will be conferring with the jurats. Not the least because, as I think Mark and I were discussing yesterday afternoon, defendants may well feel a bit disgruntled and perhaps concerned about the basis on which they were sentenced, and feel that they are entitled to a reasoned decision, which is not an unreasonable position for them to adopt. Of course, it's the bailiff that actually delivers the sentence, or explicitly announces the sentence in court, and to a degree, therefore, the bailiff should be capable of giving any reasons that it's felt necessary to explain or to justify what the sentence is. So clearly, he needs to be a part of that conversation with the jurors.
That's what gets transcribed and goes up to the so they can see what the basis is. It's quite formulated.
As you can also see in 1.42, then there is the possibility that there's a material disagreement between the prosecution and the defence as to the basis on which the offence has been committed. Material in the sense that it could have an effect on the sentence, either the length or severity of the sentence, or indeed the type of sentence that the court would be minded to impose. So in that type of situation, if the prosecution and defence cannot agree on a version of facts as to how the offence was committed, essentially, then there'll need to be what in England and Wales we call a Newton hearing. So a fact-finding exercise, not in terms of determining guilt or innocence, but just factually what happened. Usually in terms of physical actions, but occasionally, I guess, in terms of state of mind of the offender. So that will be a fact-finding matter, and therefore it's for the jurors to specifically determine that.
So you've got 3 possibilities. You've got the facts which you accept as the you've got the defence version of facts. If the prosecution doesn't want to meet in hearing, doesn't say that it doesn't care, then the court has to sentence on the defendant's version of facts. But then if there is something material on the prosecution, the defendant's version of the then you have to go through the meeting to determine whether it's the facts as well, whether it's in dispute.
Yeah, only for that last situation to occur, obviously the prosecutor has to have some material that they can actually offer on that point, and that they feel inclined to do so. I mean, if you had, for instance, if you had a complaint, let's say you had a charge of like a street robbery, where the prosecution's according to the victim of the robbery, the attacker had come up with a knife, held the knife, blade of the knife to their throat, said, "Give me your purse." She'd handed over her purse. They parted on good terms. She then went to the police. According to the defendant, when he was arrested, yes, all right, he is the assailant, he is the attacker, but he didn't have a knife, he didn't have a weapon of any sort. He simply approached her, maybe kind of grabbed her around the throat, something like that, with his bare hand, said, "Give me your purse," and she gave him her purse. They parted company, etc., etc. So the one example, you have the use of a weapon, and the other, the defendant's version, you have a less serious version of how the offence. So on either version, he's guilty of robbery, but one, the court will take a more severe view of the offence and its consequences for the victim. Now, that's the sort of situation where you might well have evidence being called, where the prosecution would not be prepared to just kind of wade through the defendant's version. But it may well be that they have a view about the, should we say, the robustness of the victim. And they just make a tactical decision that it wouldn't be in their interests, I mean, in the victim's interest, to call them as a witness simply for these purposes and expose them potentially to. I mean, it's probably not going to be very, very severe cross-examination, but just the trauma of being in court, seeing your assailant there, unless we're going to start putting screens up and things like that. So even if there may be circumstances where even the prosecution are not particularly happy to go along with the defence version for tactical reasons, they might just decide it's not worth pursuing the matter any further.
And the court
Yeah.
doesn't want to be patted up with those sorts of areas anyway, because anything that was sentenced to it's the
Well, that's interesting, because I was going to say, actually, sometimes you do get the feeling that it's the court that kind of is nudging the prosecutor to say, look, I've read the papers here. Clearly, the defence version is a load of hooky. Yeah, I mean, obviously, that's one of the things that Newton says, actually, if the defendant's version is incapable of belief, so far-fetched as no one could possibly find that as a fact, then you don't need to go through the pantomime of going through evidence to get to an inevitable conclusion. So,
I mean, of course, it's to some extent, we ask them to compare so there's no comment interview is perfectly entitled to, and aside from the conversations that have to go between the prosecution and the defendant to establish some sort of basis of theory, you may not actually realise that there's quite a substantial difference until a bit later on, by which time it's late to start with an interview, and it just be rusty around and get on. And I would say my view is that at the moment, is evolving, and that the prosecutors, Ian Russell, the head of the prosecution, is looking at people doing a more clear, basically. And I think that may be part of the intention is that everybody hasn't had to argue what the issues are.
Okay, so moving on then to the Royal Court's jurisdiction as an appeal court. You can see from 143 where we have either a conviction or some conviction and sentence. Then the defendant has the right to appeal either against conviction or sentence or both to the Royal Court. If the defendant's been acquitted by the Magistrates' Court, then it's possible for the prosecution to appeal, though there are limitations. So we need to think about those. You can see 144. So we've moved away from the 2008 law now into the Magistrates' Court Criminal Appeals Guernsey law of 1988. So no prosecution appeal against an acquittal unless the magistrate certifies a contested question of law or mixed law and fact, and desirable for that matter to be decided by the Royal Court. So in other words, unless you get a certificate that the matter is fit for appeal from the judge of the Magistrates' Court. Where the defendant is minded to appeal, as you can see again, there are some restrictions there. The 88 law provides no right of appeal against conviction or sentence, where any other law or ordinance provides that decision is a final decision. Okay? And no right of appeal where the defendant pleaded guilty, but it says the defendant can apply to the Royal Court for leave on the ground of exceptional circumstances. Now, I would imagine, I don't think I found a case on this, but I would imagine that that would include situations where the defendant, same as applies in England and Wales, if the defendant is saying that they were coerced into entering a plea of guilty, for example, in order to protect a partner, for example, that might be an example of an exceptional circumstance. And obviously then the Royal Court would need to investigate that, probably hear some evidence from somebody to determine whether there was kind of an argument of duress. I mean, presumably you might be arguing duress in terms of committing the offence in the first place, but just duress in terms of the plea that was entered. You know, you're going to take the fall for me, aren't you, Ollie? Yes, you are. Yes, yes. Yes, yes.
When appeals generally are absolutely on limits, restrictions, and that sort of thing. That's a nice little point there about the possibility of an extraordinary appeal, even after it is.
So, appeal against sentence, you can see 145 then. No right of appeal against sentence unless the sentence exceeds one or more of these penalties. And that first one, imprisonment for 7 days, takes us back to a point I think that Mark was referencing yesterday of magistrates down the ages who, when dealing with multiple offences, have imposed multiple 7-day periods of imprisonment in order to deprive have the unintended consequence of depriving the defendant of the right to appeal against the sentence. So you can see, imprisonment has to be imprisonment for more than 7 days, has to be a fine, more than a fine of level 2, compensation £75, or confiscation up to a value of £75, or suspension of a licence or permit for more than 7 days. And as you can see, if none of those penalties is exceeded, in other words, this is a fairly inconsequential case. I mean, and practitioners don't like me talking about trivial matters because they regard criminal proceedings of any sort as inherently serious and to be taken seriously. But I think that that little kind of menu of sentences there would be reasonably understood to indicate these are fairly trifling matters that shouldn't be, as Catherine says, clogging up the court system, basically. So as you can see, if one of those sentences, or if the relevant sentence isn't exceeded, then that's also not just going to impede an appeal against that sentence, but it would impede an appeal against the conviction on which that sentence is based, or almost on a kind of de minimis principle, really. So it's not to say that you couldn't appeal against conviction, but you'd have to get a certificate from the magistrate's court that there's basically that it's worthy of appeal, either as a question of law or mixed law and fact. There's an interesting, again, a kind of looking at it from a different perspective there, that case of X against the law officers of the Crown. See if I can find it, so quickly have a look at that. But it's an interesting one because the sentence, it's a juvenile case, and the sentence that had been imposed was a supervision order. So as you can see, the right to appeal, excuse me. So this is paragraph 5 of the judgment in the X case there. So different enactment, Criminal Justice, Children and Juvenile Court Reform, Lady Guernsey Law, 2008. These are so long. But anyway, that one. But the reason for referencing that case here is because you can see there, section 5 sub 4 of that enactment says the provisions of the Magistrates Court Criminal Appeals Guernsey Law 88 shall apply to, etc., etc. So that's why it's a relevant judgment as far as this provision is concerned, because it's the same provision there. Now, I've also highlighted this sentence because it's one of these cases that has multiple functionality. So you've got this point in here about exercising court's inherent jurisdiction to sit in private. That's not why I'm taking us to that now. So let's come down here. Paragraph 7 then. Appellant was sentenced to a supervision order, and that's not covered in that shopping list of sentences that have to be exceeded. Yeah, it's just not there. So what the court said there was they were satisfied that meant that that section wasn't engaged at all, and that in order to appeal, you didn't need to get a certificate from the court. Okay, and there was the section 2 that said unless you get a certificate from the court, if these sentences are not exceeded, you cannot appeal the end. Yeah? That didn't apply because this was a sentence that wasn't on that shopping list. Okay? So rather than saying it's not on that shopping list, you can't appeal under any circumstances at the end, the court took the precise opposite view of that and said because it's not on that list, yeah, you can just appeal. Yeah.
Someone would ask him for a declaration of incompatibility and might have issued it.
Well, yes, that's the point that he makes at the end of that paragraph. Obviously concerned about the human rights.
He's your brother. But you need to, you don't just throw it in. There was a great tendency when human rights were in hands in 2000 people used to just use it to fight for the judiciary. You know, with the day-to-day person argument, case law, the whole thing. But he is very engaged on all of those working groups. Do not forget, he is an editor of Blackstones. He remains an editor of Blackstones. So he's quite serious in his own right.
Right, okay, so approach. So we can see at 1.46 then. In the same case then, the court held that the basis on which an appeal could be instituted is not specified by the 1988 law, and that's actually coincidentally what you can see in paragraph 8 as we kind of move on through that judgment then. Further appeal lies to the Court of Appeal pursuant to section 7 of the 1988 law, and it was said that this further appeal engages section 25 of the Court of Appeal Guernsey law 1961, and so the Royal Court would import the grounds that were set out in the 1961 Act for a matter that goes from the Royal Court to the Court of Appeal into an appeal from the Magistrates' Court to the Royal Court. Okay, and there are a number of judgments that say that. So as you can see, for example, in 146, it says the court in X was very clear that it was following an earlier decision in the Ogier and Lanuri case. So to set aside a verdict solely on a question of fact requires the verdict to be obviously and palpably wrong. And in an earlier decision, earlier than X, that is Nicole or Nicole. I'm worried about where I'm putting the emphasis now. Nicole. Okay. Wouldn't usually interfere with findings of fact made by a judge sitting in the Magistrates' Court unless there was no evidence to support his findings or the findings were such that those of the judge giving himself proper direction could reach them. So a fairly standard test, really, as far as appeal is concerned. What can the Royal Court do? 1.47 then. It can confirm, reverse or vary, send the matter back to the Magistrates' Court with its opinion, which could, I suppose, be a direction that the defendant is clearly guilty and should have been convicted, or the opposite way around. As it says, make such other order as is just and exercise any power that might have been used by the Magistrates' Court. And as we move on to page 17, you'll see it says there, defendant, where it's the defendant's appeal, the Royal Court has the power to impose any punishment that was open to the Magistrates' Court originally, whether that's less severe, which the defendant would always like to be the case, or more severe. And again, that's there's a very close resemblance to an appeal from the Magistrates' Court in England and Wales up to the Crown Court in that situation. That's because certainly in England and Wales, the defendant has an unfettered right to appeal up to the Crown Court. So basically, you can kind of go for two bites of the cherry, essentially, and it would be a complete rehearing, which it wouldn't be here, but a complete rehearing. So really, two very solid bites of the cherry in England and Wales, with an appeal up to the Crown Court from a conviction in the Magistrates' Court. And the reality is, one of the few disincentives that the system puts in place because if you're a defendant, you've been convicted in the magistrate's court, you know, your advocate says to you, well, if we appeal this, there'll be a complete rehearing. The matter prosecution starts from scratch again. It's going to have to prove its case beyond a reasonable doubt. The defence is going to be saying, well, yeah, knock yourself out. Let's do that. Why, you know, why wouldn't they do that? You know, it'd be a mug not to. Although I have represented people who said, I don't want to appeal this. Anyway, so there needs to be some kind of filtering process to just kind of knock out the chancellors who otherwise, again, would be clogging up the system, saying, well, right, let's have trial mark 2 then. Yeah. So the idea that they could actually, if the appeal failed, face a harsher penalty than was originally imposed is usually seen as that kind of discouragement. Because you can say, well, yeah, we can appeal. This won't be a rehearing in Guernsey, but we can appeal. And the defence can be saying, what have I got to lose? And the answer might be, well, you might face a harsher punishment. So current sentence, the existing sentence imposed by the Magistrates' Court would be a relevant part of that conversation about do we want to appeal against the conviction.
And there's a going on with that at the moment. Less so Magistrates' Court rule that the Court of Appeal has made it clear that unmeritorious offence will be not reviewed to this sentencing. So it's very valuable now. And also,
So someone's punishment for bringing an unmeritorious appeal as opposed to an increase in sentence because the crime warranted an increase in sentence. Well, they wouldn't say that, but it looks like.
Yeah.
Which we all thought was reasonable and but absolutely so I think there's very, if you asked him, there's some question about advising appeals, that's very well. I try to find that there's a particular case where it said that it applies, I mean, the Royal Court is not, the appeals are not welcome generally.
Defendants are welcome generally.
Well, defendants are only welcome if they're passing appeals are not welcome. And so, and that's been happening over years as well in this business now, that one has to prove the judge's directions, which sticks in my brain. Less of making less of his directions and appeals, but now you have to, if you use your directions in advance, you have to say that it's like that, it's beyond, you need to tweak it, and that's so much to the defendant's system. It's a hostile environment.
Yeah. I mean, that's happening more and more, isn't it? That you're almost being kind of brought in as part of the team, really. And you're right. It's not doing the defendant. Well, I mean, judges will no doubt say it is doing the defendant a favour because it means the judge is more likely to get things right in the first place rather than having to be corrected by the appeal court. But, it does kind of stick in the throat. Okay. Right, so further appeal then, 148. As you can see then, excuse me, it's possible to take the matter onwards to the Court of Appeal with leave, still under the Criminal Appeals Law of 1988. But as you can see, that appeal can only be based either on a pure question of law or if you get a certificate from the bailiff, there are sufficient grounds of appeal. And that's against conviction or acquittal. It seems that there's no further possibility of an appeal against sentence if you still don't like that. Right, still a little bit to go here. Court of Appeal then, the ultimate appeal court as far as being within the bailiwick is concerned. Obviously there's the possibility of going to the Privy Council, as it says, there's kind of long stop there, and I guess there is also the possibility of going to the European Court of Human Rights in Strasbourg once you've exhausted all possible domestic appeals. So as you can see there, the main law that we're looking at for the Court of Appeal is the 1961 law. In terms of constitution, again, there's not really a great deal of value to add to what you've got there. You'll note that there are certain ex officio appointments. So, for example, the bailiff here is a judge of the Court of Appeal. I think also the usually it's not an ex officio appointment, but the Jersey bailiff is normally appointed as a judge and will, from time to time, anyway, sit as a judge in the Court of Appeal here.
Vice versa.
So as you can see, when the court does sit, it has to have at least 3 judges, and however many judges it does have, and I think from time to time it's sat with 5, or sometimes more than
I
5.
think it's sat with 7.
Yeah, I think there was a 7 judge example.
I mean, they also draft in old bailiffs, so you'll see that a certificate carries that quite a long time in the appeal after he had ceased being bailiff. So that's something that happens as well. Yeah, they did the 7-hander when they wanted to lay down guidelines.
Yeah.
That was the sexual offences one thing.
Sounds right, yeah. Okay, so as you can see, and again, quite normal, you can't sit in the Court of Appeal to hear an appeal from a matter that you've previously been judicially involved with. Fairly common sense, really. And it's just a straightforward majority decision in the Court of Appeal. 152, only members of the Guernsey Bar are entitled to practice in the Court of Appeal. Not sure that there's anything else to deal with there, really.
Yeah.
Sorry, go on.
Yeah, when I read that, I just 152. I just wondered if we needed to make clear that the procureur or controller or one of the law officers would always be there for the prosecution, because with very few exceptions, all prosecuting is done by the law officers' chambers. I mean, there are occasions when advocates in the private bar prosecute for whatever reason, but they're rare. It was just the way that I read it, just to make sure that everybody understands that you will have the procureur or the controller, or more usually, to be fair, the criminal team.
I think that's a very fair point. Yeah. And there's just this weird case. I'm not sure that we need to really pay too much attention to it. Of the law officers and Kirk, who I think is slightly an interesting individual. Should we leave it at that? Who wanted to have a law officer of the Crown appointed to represent him, and the court just basically kicked that straight into touch. So it's not happening. All right. So right to appeal, Section 24 of the 1961 law. Somebody who has been convicted can appeal to the Court of Appeal against their conviction on a pure question of law. Otherwise, you can appeal if there's a certificate that the matter is fit, that from the trial judge, or you get leave from the Court of Appeal itself. You can appeal against sentence, leave of the court, unless it's one that's fixed by law, and you can also appeal against the minimum term of imprisonment where sentenced to life if you get leave from the Court of Appeal. So pure question of law, an example, is one of the many de Kock, I don't know how you pronounce it anyway, de Kock, right, judgments that you can find in recent unreported judgments. I think I've got the right reference here. It looks a little bit weird because it was a decision of the Court of Appeal in 2017, but its serial number is, and I checked this last night, is indeed 33/2016. So don't ask me why. That's probably just when it started its life in the Court of Appeal of Greff, but it didn't get a decision until 2017. But you can see there various decisions were taken by the Deputy Bailiff on preliminary applications, usually in terms of the admissibility or discretion to exclude, and decided not to exclude prosecution evidence. And Mr. de Kock was saying that they were ABC Picture Houses, Wednesbury, unreasonable. And that's picked up in, I'm going to say paragraph 5. I was going to show it to you, but it's still only on page 18, so you need to crack on. But paragraph 5 of that judgment is where you see that particular point being made. If there's an appeal based on a complaint about the facts that have been found, as you can see, then that's still same case of de Kock. And the court referred there to an early decision in Pinto, I think it's Pinto and others, from 2013, which was, as it said in de Kock to be distilled into 4 principles, although, as my footnote says, rather curiously, when it was actually enunciated in Pinto, it was only 3 principles. So somebody in the Court of Appeal has then decided that they could do a better job of actually structuring and setting out these principles, and they've turned it into 4 there. So, as it says then, there is a distinction between the Guernsey Court of Appeal and the powers of its equivalent in England and Wales. And as it says, over in England and Wales, you've got the idea of an unsafe verdict and potentially, although I think it's a bit contentious in England and Wales these days, a lurking doubt leading to a successful appeal against conviction. And that kind of just gets us back to that point that I was mentioning earlier, that the test for an appeal against conviction here harks back to the 1907 Criminal Appeal Act in England and Wales. So there's a big disparity between current case law in England and Wales about grounds for appeal or how to successfully appeal against a conviction and what would be pertinent as far as this jurisdiction is concerned. A second principle then, when making some kind of judgment about whether the original verdict of guilty was right or wrong, the court has to bear in mind, it says the function of fact finding has been left to the first instance court, and in particular if credibility has been challenged, as it has been in a number of recent cases, particularly maybe where a defendant is charged with sexual offences against young people, and there are allegations that they just lied, they just made these things up, they've invented them, it's all been fabricated, nothing happened. So there may be allegations of lying, there may be allegations of collusion being made there. So it says the lower court has had the advantage of actually seeing those witnesses, usually live at some point, perhaps through a live link and a recorded interview, but actually has had the advantage that the appeal court has not had, and obviously, of course, also hearing from and seeing the defendant being questioned. Third principle, verdict of jurors are to be treated with particular deference. So a kind of a distinction there from, let's say, a jury in England and Wales, holders of judicial office far more experienced than a transient juror would normally be, who probably only does, 2 weeks of jury service, if that, in their entire lives. So they're much more experienced. And as it says there, fourth point then, verdict of jurors does not normally disclose the reasons for which the verdict is based. So again, that gets us into potentially a human rights discussion about your entitlement to have a reasoned decision, and indeed, how can you challenge a decision if you don't know what the rationale for it was. The Court of Appeal has tended to go down the road of saying that the rationale should either be obvious because of the evidence and the arguments that have been presented at the trial, or through any perhaps remarks that were made by the bailiff when it came to passing sentence. Okay, so as you can see, question of whether there is sufficient evidence to support the conviction for obvious reasons won't normally be regarded as a question of pure law, because there will be further questions of fact. So it would be one of those mixed law and fact issues. So you'll either need to get a certificate from the trial judge. I don't know how often that happens, how often it's sought here. In my experience in England and Wales, it's very seldom sought, and it's even more seldom granted, because it's almost like a kind of suicide note written by the trial judge. Yes, yes, counsel, I would like you to humiliate me in front of the court, in front of my learned Lord Justices of Appeal. Yes, let's take the way I handled this trial up there and see what they make of that. They're not going to give you a certificate. So, although legally it's possible to get that 99 times out of 100, 999 times out of 1,000, you're going to have to go to the Court of Appeal to get leave from there. What else do we need to think about?
Well, they normally deal with it as one hearing.
Yes.
So they effectively deal with the appeal on the basis that it's the application for leave, and then they dismiss it and they don't leave. That has caused some technical problems with legal aid, But they now seem to be granting legal aid when you lodge your appeal, and it runs until the determination. But it did cause some problems at different times. But I've just lodged an appeal for Hammond, which was lodged out of time. I haven't been told what's happened, but the transcript on its way, so I'm assuming that leave to extend has been granted.
Yeah.
You don't know what's happened until the end, really.
Yes, I'm just having a look here. Hewlett. Let's just have a quick look at that. So yeah, this is a fairly recent one, 2016. Gary David Hewlett. And as you can see there, paragraph 1, this is an application for leave to appeal. This was against sentence. Okay? Leave to appeal against a sentence. Leave to appeal was refused by the single judge, which was the bailiff. Applicant now renews his application to this court. And that's something else that we need to bear in mind. The single judge of the Court of Appeal can exercise almost every function, certainly as far as granting leave is concerned, but almost every function of the full Court of Appeal. So this application for leave would usually go to a single judge first. And obviously, if the single judge knocks it back, then you can renew your application. So we can see that it's an application for leave to appeal there. And it goes on and on. Let's quickly zip down here. So they're looking at all of the merits. And then here we are, paragraph 60 out of 61. In all the circumstances, we grant leave to appeal against sentence.
Yeah. You don't know it's happened until it's happened.
So they've spent the intervening, 58 paragraphs actually looking at the merits of the appeal against sentence. And they leave it right to the penultimate paragraph to say, so we're granting you leave. At which point, you presumably breathe out a massive sigh of relief. Go, well, thank goodness for that then. Unless you kind of took a view that it was coming down the line. Because
what is a decision, really?
Yeah, but anyway, so
as long as you get your legal aid either way, it's okay.
Yeah. It's an interesting way to approach things. Yeah. Okay. All right. So I think that's 156 dealt with. 157 procedure then to think about with that. And again, there's probably going to be some duplication of what we're looking at here with what we'll look at next time in chapter 10 on appeals. But anyway, as you can see, must give notice of either your appeal, if you're entitled to do that, or your application for leave within 10 days of the conviction, although that period can be extended. An extreme example, I don't think I can put it any further than that, an extreme example came in Fernandez, sought leave to appeal against the recommendation of deportation, made the application at the time, 15 months late. So as it says, the proffered explanation was he'd been in prison, unable to obtain legal representation. Well, that may have been correct, but the Court of Appeal observed that he had been represented at the sentencing hearing and had not been provided with any information as to the seeking or giving of legal advice on appeal at that time. Now, we should just, I think, note that footnote reference there, 113 to Practice Direction 2 of 2015, which says that, and this is again quite consistent with practice in England and Wales, defence advocate should advise the defendant on possible grounds of appeal, whether it's appeal against conviction or appeal against sentence, immediately after the trial has concluded. That is considered, coming back to Catherine's point about legal aid, considered to be part of the trial in the Royal Court, and therefore if legal aid has been granted for representation at trial, it will extend to cover that advice following conviction and sentence. Yeah. So in other words, given that he had been represented in the sentencing hearing, he should have had advice, that legally qualified advice at that point. Okay, and you see there the emphasis was the short period of time, which is this 10 days idea. Short period was to assist with legal certainty, finality, so that we all know where we stand. Basically, people can get on with their lives. 158, your notice of appeal has to include the grounds, and this is again the practice direction. It says the ground should be substantial and particularised, not a mere formula. Now, I don't have an example of grounds that I could offer to you, But I would say what that's basically saying then is they have to be made case specific, fact specific.
So if you're doing an appeal against sentence, the usual ground of appeal for sentences is it's manifest. It's not sufficient simply because it's manifest excessive. So it was the wrong starting point, and they didn't factor, they didn't attach sufficient weight to mitigating factors. There's a disparity between the sentence of pensions. You have to put some meat on those. If it's a law one, you've got to know where you need to start. If it's an appeal which is about the incorrect decision to admit evidence to test that you think shouldn't be permitted, and that the learned judge incorrectly implemented the use of a screen or the whatever it is rather than that. So you've got to be quite particular. Of course, you will then be able to perfect your grounds later because you will get the transcript. Although what they do now is they ask you to identify those parts of the transcript that you actually need, rather than just transcript. I don't know what happens in England, but
That's the same because they always say it's too expensive
well,
to
it's
get the whole
also
transcript.
You'll be opening mitigation and the sentencing laws, that's not difficult. But where it's a legal matter, for example, where it's an extreme evidence, so like the cop, for example, we had to go back and work out when it was that we had discussions about points along the way, which is fine when we had an application and there's been determined on a particular day on the judgment, but despite the fact that there seems to be reported judgments on the top, there were so many other discussions of the other duties. So I kept renewing every single application about the exclusion of the evidence every time we went back to court. And so we had to find all those we just got the but it's something to do with keep a rough tally of when you're making points roughly when they are. But that's what it means about the you've got to be very specific.
Is that just work on a transcript to be covered anyway, or is that the equivalent of the civil transcript and the whatever in one transcript?
Well, legal aid for appeals works slightly differently. It's not done by the legal aid service, it's done by the court of appeal itself. So you've got the roles for the notice is embedded in the document here. You apply for legal aid directly to the court of appeal, and the court of appeal answers to you, so you go to the court of appeal, it doesn't go to the legal aid service. And if they say that you've got legal to appeal and you've got legal aid and you produce the transcript, otherwise they'll give you a price for it, and you'll have to pay for it.
And but if you're willing to pay for the full transcript, then that's fine.
But they won't. It may take a while to get it transcribed because we don't have simultaneous. From what you call it, but it's digital recording here.
Yeah, no, I think it's pretty much the same.
Stenographer.
No, the stenographer is a dying or dead.
Oh,
Yeah,
okay.
yeah. No, everything's just recorded. So it's not like you've got someone who's been doing the recording that might have a recollection of, oh, it was day 3 when that discussion took. There's nothing. It's just a recording device that's just whirring away. So.
No, we still have greffiers sitting in almost every court, and they keep log notes, and they can be very useful to us if you're not sure when something happened.
Okay, so powers then 159. So as you can see on an appeal against conviction, the appeal will be allowed if the court considers that the verdict should be set aside as unreasonable or not capable of being supported by the evidence, or should be set aside because of a wrong decision taken in the question of law, or on any ground there's a miscarriage of justice. So this is section 25, and this is what's going back to the 1907 England and Wales Criminal Appeal Act. Those grounds were the grounds from 1907. Okay, so they're not the current test. The current test in England and Wales would be, is the conviction safe or unsafe? End of discussion. As you can see, there's a proviso. That doesn't apply in England and Wales anymore, although it used to. So proviso, even if there is a meritorious ground of appeal, if there's been no substantial miscarriage of justice, then the court can dismiss the appeal. Okay. don't think there's anything else I wanted to pick up from that particular paragraph. All right, so appeals against sentence. The court, if it feels that a different sentence should have been passed, it can impose the new one, having quashed the original one. Again, and this is again a departure from the position in England and Wales, that sentence could be more severe. It would have to be within the jurisdiction of the Royal Court to have imposed in the first place, but it could be a more severe sentence there. Collins against the law officers from 2011 is an interesting little case. There's not a lot going on in it really, but as you can see, the defendant had been prosecuted for breaching his bail conditions by running away, and was sentenced for that offence to 3 months jail time. Now, this sentence was determined by the judge alone, and that's because I'm not going to bring that up, but there's a little discussion that they referred to in the judgment where the bailiff said, I think this is a matter for me and me alone, isn't it? And the advocate went, yes, it is. So the bailiff just cracked on and heard the evidence and determined the sentence. And the Court of Appeal said, no, it's a sentence, and therefore it's a matter for the jurats to be involved with. So as you can see, they set aside the 3-month jail term that the bailiff had imposed on the basis that he had erred in law. Okay, so technical merit, when they say it's technical merit, that you know that's normally because of death for any practical benefit for your client. They then said that they would work out what the appropriate sentence was for themselves, and amazingly came up with 3 months jail time. Yeah. So there we are. It's one of those, we go and see your client, assuming they haven't been present in court for the hearing of the appeal. You kind of, they say, what? So how did it go? You go, well, there's good news and bad news. Good news is we won the appeal. Bad news is we're still doing 3 months. Okay. So client says, well, how did that happen then? Well, let's have a chat. Okay, so bail pending appeal. You can see the court has the power to release an appellant on bail pending the outcome. If that happens, the time when he's out on bail will be disregarded, fairly self-evidently really, when they compute the term of any jail time to which he's then sentenced. And I guess maybe the key point which I should have put in there is that in terms of when the Court of Appeal does release an appellant on bail pending the outcome of their appeal, usually that's where they've received something like, say, Mr. Collins, they've received a fairly short sentence of imprisonment, and the court feels that by the time they actually get around to a substantive hearing of the appeal, they will serve that sentence. So if they were to quash the conviction or quash the sentence, it would be a kind of Pyrrhic victory, certainly as far as the sentence is concerned, for the defendant. Because they go, oh, great, so I didn't have to do 3 months then. No, the court said that was not the sentence. It shouldn't be imposed. Yeah, terrific, I've served it, so where's the benefit? No, there isn't one. So that would be a classic example of where they would be certainly thinking about release on bail, just to preserve any kind of meaning to an appeal against sentence.
And the Court of Appeal sits once a year in the Times Online, or calendar, so it's worth being roughly aware when the Court of Appeal sits out, because it might be a relevant piece of advice.
Yes. All right, well, I mentioned the single judge a few minutes ago. So 162 just sets out what the single judge can do. So as you can see, we've already thought about this, granting leave to appeal, extending that time beyond the 10-day period, can assign legal aid, allow the appellant to attend hearings, and make a decision about release on bail. So all of those things can be done by the single judge. And if you don't agree with the outcome of those, presumably you're going to think about taking it on to the full court, see what they think about it. 163, substituted verdict or sentence. Again, this is a fairly typical power that courts of appeal have. So as you can see then, usually what happens if the court allows an appeal against conviction, it just quashes the conviction and directs a verdict of acquittal be entered. But there will be circumstances where it quashes the original or the conviction for the original offence, but then substitutes the conviction for a second or an alternative offence there. Yeah. As I said, you can do that as it thinks proper. So if the defendant succeeds in an appeal on part of an indictment, but on other parts the court holds that he's been properly convicted, it can affirm the sentence, it can substitute a different sentence such that it thinks is proper. And 164 if he could have been convicted of a different offence and the court considers that the trial court must have been satisfied with facts that would show him to be guilty of that other offence. Okay, so it can substitute a verdict to guilty and then was convict for an alternative offence and then pass sentence for that. In that instance, the substituted sentence cannot be more severe than the original one. Okay, so unlike the general power on an appeal against sentence, it could be a more severe sentence. Here, when they're substituting, it cannot be a more severe sentence. So again, that's an interesting difference, basically. All right, 165, I think, is a very short point that speaks for itself. Privy Council, 166. So you can see there, the relevant rules are in the 2009 JCAJ rules. So Rule 10, where permission to appeal is required, then the Judicial Committee won't hear the appeal unless permission has been granted for it, either by the domestic court, which in this case would be the Court of Appeal here, or you've got leave from the Judicial Committee itself. And as it says in criminal matters, it seems that one may only proceed with special leave from the Judicial Committee. There is no equivalent of Section 16 of the Court of Appeal Guernsey law from 1961. Yeah, and that was considered by the Judicial Committee in the case of A versus R, which I think is a SARC case, if memory serves me correctly.
Yes.
And which we did discuss in civil procedure last term. But as you can see there, it was said by the Judicial Committee that that was an anachronistic provision that was causing uncertainty as far as civil matters are concerned. But there doesn't seem to be any kind of, as it says, controversy as far as criminal appeals are concerned. It does appear very simply that you have to get special leave from the Judicial Committee there. An example of that happening is Sherry against the Queen, which there is a typo there, occurred in 2013. It's not due to occur in about 95 years' time. So it's 2013, not 2103. Fairly self-evident there. Again, that's an interesting case. It's more extremely, talking about Fernandez kind of being, 15 months late in bringing the appeal there. Well, Sherry, as you can see, some 13, he'd already had a couple of goes before 2013. But yes, 30 years too late. He received a jail sentence, a custodial sentence, in his absence, having departed to the mainland. And then I think on various occasions, for different reasons, wanted to come back, or at least open up the possibility of coming back to Guernsey. And I think in particular what motivated this specific appeal was he discovered that he had a by then adult daughter in Guernsey, whose existence he'd only just learned of, but he was aware that there was effectively a warrant out for his arrest should he return to the jurisdiction, and he didn't want to serve the, I think at that point, it was something like a 56-day jail term. That was, I'm going to say that was all it was. That was all it was, 56-day jail sentence. Not least because when he'd disappeared initially, the court had, I think, added on, so he disregarded some of the time he'd served. He'd been in custody on remand, and the court disregarded some of that time such that he effectively doubled the length of his sentence, and he objected to that. So he wanted to come back and see his daughter. Don't know why she couldn't go and visit him, but he wanted to come back and visit her. So it was 30 years down the line. As you can see, he successfully sought leave to go to the Privy Council to argue at that point. I mean, it's an interesting human rights point there in terms of what respect for family life, perhaps, how the system interacts with that. But the substantive, he got leave to appeal, but the substantive appeal was unsuccessful. So there we are. Practice direction. So 1.68, the practice direction, you can see, says that the Judicial Committee has complete discretion whether to grant leave or not, but where leave cannot usually be granted by the Court of Appeal, it is mostly granted in criminal cases. And so it says that applies to Guernsey, because if you look at the practice direction, it has a list of states or territories that will be covered by that principle, and in the list, relatively short list of Crown dependencies, we find the bailiwick of Guernsey. So, yeah, there we are. Okay, and I think it's children through to the end of this chapter, and then we've done about a quarter of the work. Okay, so children, juvenile court. So something that we've mentioned in passing already: criminal justice, children, and juvenile court reform, bailiwick of Guernsey law, 2008. I don't have a snappy acronym or mnemonic for that. I'm sure you can think of something. I just think of it as a juvenile court reform law, and that's about as short as I can get it there. So as you can see, when the magistrates court is dealing with a child defendant or child offender, presumably on their own. I don't know. I mean, certainly in England and Wales, if a child defendant is jointly charged with an adult defendant, they'd appear in the magistrates court, not in the juvenile court. Not the same applies here. Yeah. So this would be the law that would apply when we have a solo juvenile defendant, or we have multiple, but they're all juvenile defendants. So juvenile court comprises the magistrate sitting alone, and as it says, the primary statutory aim for the juvenile court is to prevent offending. That's the same as it is in England and Wales, effectively. Child is defined in the 2008 law as somebody under the age of 18. Excuse me. And there's an interesting point, part 5 of the 2008 law, which is the part that deals with bail and remanding defendants into custody. As you can see there, defendant is defined there. We've got child defendant or child offender, and they would be aged under 17. So there's an interesting gap, if you like, in terms of those provisions in part 5, only applying to those under 17, and therefore not applying to those under, or between 17 and 18. They've had their 17th birthday, but not their 18th birthday, and would be appearing in the juvenile court. But in terms of bail issues, you'd be looking at the main bail law and not these provisions in part 5 of the juvenile court reform law.
And does that apply for when the age really is committed, or whilst they're in the court?
It's just the age as they're processing through. Yeah, because it's not a sentencing point. It's just what provisions are going to be active in terms of bail here. Yeah. So, for example, I think I'm right in saying, just as an illustration of how that might be significant, in the main bail law provision, which hopefully we'll be seeing today, there are various exceptions to the right to bail, and it talks there about for child defendants that one can remand them into custody for their own welfare. Yeah. Well, under Part 5, that doesn't apply; it's repealed. Okay, but so that for the under 17, for the under 18s, the under 17s, get it right. For the under 17s, their own welfare is not a legitimate reason to withhold bail from them. But presumably, for someone that is 17 but not yet 18, yeah, presumably because the main bail law says you can remand them in custody for their own welfare, and that's not taken away by Part 5 because they don't fall in Part 5 because they're over 17. That suddenly resurfaces as a legitimate reason for denying bail or something. All right, what else do we need to think about then? Court has jurisdiction over children from the age of 12 because that's the age in which criminal responsibility kicks in. So again, that's different from England and Wales because it's 10, and it runs up to the 18th birthday. So in terms of initial stages, this can get quite complicated. So if I start talking absolute gibberish, feel free to step in and
really
slap me down. All right, so first step, from our point of view, first step is taken by a designated officer. Designated, as it says there, you deal with child defenders by a police officer, superior police officer, an inspector rank or above. So if a designated officer considers there's sufficient evidence for a child to be convicted of a criminal offence, or it's a realistic prospect that they should be convicted, Then they will make a report of the crime to the children's convener, but also to the procurer if it's thought that prosecution might be necessary in the public interest. And you'll note there's a specific provision as far as traffic offences concerned that they must be reported to the procurer, whether that's because there's a particularly high incidence of joyriding by juveniles,
Just speeding,
Yeah.
not having arm plates,
Yeah.
and that sort of thing.
no insurance.
Yeah.
So as you can see, in terms of whether or not the designated officer should report the matter to HM procurer, relevant factors include the nature and gravity of the offence, if the child is a frequent flyer, their age, so how young they are. If they're like 12, 13, that might be a good reason for not embroiling them in the criminal justice system. Anything that has previously been done by way of a sentence or disposal to the child, how they have responded to them, and obviously anything else that would appear to be relevant.
It might be relevant just to say that the rules of engagement are slightly different. Because when generally advising defendants at the police station, there is an and we can, not today because we need to get on with it, we can talk about it some other time. With a juvenile defendant, as long as the offence is not serious, then one might encourage a juvenile defendant to make admission in circumstances where he wouldn't do that with an adult. Because if it's down to the tribunal and it's going to look holistically, they're going to be looking at, why is this person offending? Why is this person not going to school? Mum and dad have split up, there are problems, what services can we put in here to help? It's unhelpful to have a juvenile client who's been advised to make no comments. But I would say this, the designated police officers are very nice, but they do not have the power ultimately to make the decision whether the case goes to the convener, goes to the prosecutor, or ends up in court. And we recently had been involved in a case where a young person was encouraged as a combination of the officer and answering the appropriate adults and anybody else to make a clean breast of it, and admitted something very serious, which is now going to court. And I have to say that I think that when advising at the police station, where you're faced with a juvenile with a serious offence, then I think that you have to keep your head on in terms of this might be going to court, and maybe there isn't any particular interest in getting somebody to admit to something really serious, particularly if the evidence is not there. So, it's just what just comes in there is a designated officer, because they do consider themselves to be quite experts in it. And indeed they are and should be respected for it, but they're not God, and they don't ultimately make the decision. So where there's been a slight suggestion that it was said that it would stay at the tribunal and with the convener, that's not their gift, it's not in their gift.
Right, okay, so 171 then, the convener will investigate and make a decision on whether the matter should be referred to the Child, Youth and Community Tribunal for a determination, and will also consider whether the matter should be referred to the procurer again. Same factors as we just looked at. So 172, procurer will receive a report from either potentially the convener or from the designated officer. Then they have to conduct a review there. It says together with all information supplied and any representations that have been made by the convener, may decide to prosecute or simply refer the matter back to the convener for further proceedings under the Children, Guernsey and Orderly Law of 2008. If the decision is made to prosecute by the procurer, they should keep that decision under review so it can be changed at any time up to conviction, if that is indeed what occurs. So what functions does the juvenile court have then? If there's a prima facie case established, it can commit for trial. As it says, any child charged with an offence which is triable only an indictment, which is back to the HRRPP ones. Those that may be tried on indictment, and either the magistrate has declined jurisdiction, again for the standard reasons that they don't have the adequate sentencing powers, or they just think it's more appropriate, maybe due to the gravity of the matter, as Catherine was just saying there, that it goes to the Royal Court, or alternatively, either the prosecution or the accused have elected trial and indictment. It's also able to conduct a trial, unsurprisingly, a summary trial, pass the appropriate sentence if they convict the child, and hear any proceedings in relation to alleged breach of an order, and as it says, pass the sentence, or otherwise deal with the child offender who's been remitted to it for that purpose. And I'm assuming that might be a situation where perhaps if there's been a child defendant jointly charged with an adult defendant, they've gone to the wrong court for a joint trial, and the child has been convicted, that maybe I don't know, maybe the Royal Court would remit it back to
I don't know.
the juvenile court. Because otherwise, I'm not really seeing a circumstance in which that's going to arise, really.
It doesn't mean remitted by the convener.
I don't think so, no. I'll check it. Yeah. Okay. So, yeah, something we've already mentioned then, typically the juvenile court is seen as a closed court. So the public do not have full access to it, and that's partly, as it says, to preserve anonymity of the accused or offenders if they've been convicted, and to make sure that they can be integrated or reintegrated effectively into the community. So there are limitations on who's allowed in. You have that list there. And as it says, even people who appear on that list might be excluded in a particular case or for a particular hearing if it was felt that their presence would have a detrimental effect on either how the hearing is to be conducted or on the welfare of the child. What else do we need to think about? Oh yeah, other courts. So we've already, I think, thought about this, and I've mentioned, I think, in this context, the X case already. An appeal of a child offender from the juvenile court to the Royal Court. The Royal Court doesn't have that statutory limitation on who's allowed to attend. So, you know, its default position is it's a public court, it's open justice, anybody's entitled to attend and see the workings of the court. But the Royal Court there decided that it could exercise its inherent jurisdiction and make a decision to sit in private. That's preserving the same principles there. In terms of not so much keeping people out of the court, but insisting on people coming in, then 176 says the attendance of some people may be required, most self-evidently the accused, whose presence may be enforced if they don't want to turn up by the court issuing a warrant, an arrest warrant, but also the child's parents. As it says, the parent of the child will be required to attend court unless the court satisfies it's either unreasonable for some reason or it's not necessary for a just hearing of the case, or their attendance will be actually detrimental for the conduct of proceedings or for the welfare of the child. Now that would only be presumably a situation where perhaps the child is accused of committing an offensive assault or something like that against the parent, or maybe the relationship has just broken down. Perhaps the child is now in local authority care effectively, so that they just don't communicate with the parent. It would serve no benefit to have the parent there. So in that situation, as you can see, 1.77, you may well have someone in place of a parent, like a social worker, to attend. But generally speaking, the court would be looking, particularly with a younger child, to have someone with parental responsibility present in court. I suspect, at least in part, to bring home to that individual that they have somehow failed in their responsibility to the child, which is why they're in court along with the child. So it's almost kind of like being a quasi-defendant, effectively, bringing home your failure in a very public way. All right, reporting restrictions, 1.78 through to 180 then. As you can see, again, this is nothing unusual. As a general rule, nothing should be reported that is an identifying detail. So fairly obviously names, addresses, but also things like school attended or school involved. And this would apply not just to material that identifies a child defendant, but also a child victim or a child witness in the proceedings. Obviously would include pictures or photographs. So as you can see, breach is a criminal offence punishable either summarily or through the Royal Court. That's fairly standard, really. And that applies, as it says there, in terms of reporting restrictions, also to the Magistrates' Court, the Royal Court, Court of Alderney, and the court in Sark as well, and any court hearing appeals. And that represents a departure from the position in England and Wales, the automatic imposition of reporting restrictions in those adult courts is different because it's not automatic in England and Wales. But again, something that's quite typical, the restrictions may be lifted where to do so serves the interest of justice. So, for example, if a child defendant was run away, had that happened to me once at Waltham Forest juvenile court, as it then was, that was still a youth court sitting on the Wales these days. But yes, my client, we had a break because he wanted to go to the loo. So he went in. It was one of those setups where there's just a kind of vestibule or lobby area immediately outside the court with a number of doors off of it, including the door to the toilets. And he went through the door to the toilets, and I was just standing there having a conversation with the prosecutor and I think 2 police officers who were involved in the proceedings. And the conversation had been going on for a while, and then somebody said, you know, he's been in the toilet a long time. And so we sent one of the police officers, they're investigators, sent one of the police officers in to search the toilet and make sure the junior was okay. And it turned out the junior wasn't in the toilet anymore. And had actually, I believe, I don't think he went out through a window. I think he'd actually had the chutzpah to come back into the lobby area, walk straight past all of us who were deeply engaged in whatever facile conversation we were having at the time. And rather than walking through the door back into the courtroom, we just walked out through the door marked exit, walked out of the building. Yeah, so there you go. Yeah, well done him. So yes, it may be that if you have a fugitive from justice, a juvenile fugitive from justice, that the court may decide to lift the embargo on naming them in order to facilitate tracing them, bringing them back into the bosom of the criminal justice system. All right, children prosecuted with adults, we've kind of talked about that in passing already. So 181, you can see that it's entirely possible, not that unusual, for children to be prosecuted together with an adult defendant. And it may be, of course, that there is some kind of element of influence of an adult over a juvenile. There may be a significant age difference involved in there. But it may also be, of course, a very small age difference. It may be that you've got a 17-year-old and a 19-year-old, two mates allegedly offending, but one of them happens to be a few months older and is therefore an adult defendant that will appear in the magistrate's court, and therefore the child defendant will also end up appearing in the magistrate's court as well. Whereas maybe 3 months earlier than that, they'd have both been in the juvenile court. Okay, so I don't think there's anything else that we need to
I think it does
explore
answer
that.
a question in the sentence.
Okay.
I think. It says, where a child appears before a court convicted, then that court may remit him to the juvenile court for sentence.
Yeah.
So I think that is the answer.
Okay. Thank you. Right. Okay, let's finish this off. Sentencing. So as you can see, 1.82, where a child appears before a court then and is convicted, yes. So as Catherine just pointed out, then that court may impose a sentence. They may remit the matter to the tribunal for consideration, which would obviously then be a non-criminal disposition.
Which is the main attraction.
Yeah.
I mean, there are two things. The fact that it's not a conviction.
Which is no doubt seen as a good thing in
Well,
most situations.
Yes, well, for people getting jobs and so forth. It's better, it's actually curiously better than a caution, because in Guernsey, cautions are not the same as cautions in England. And so if you ask for your P&C to be printed out, cautions will be on that, and they get referred to the court and all sorts of things. So you have to be a bit careful about caution use generally. But the CYCT is good for that.
Okay. Yeah, or as we can see, they're remitted to the juvenile court for sentence. All right. So, Court of Alderley has no power to remit a child offender to the juvenile court, but can remit him to the tribunal. And the Court of the Seneschal and Sark can do neither of those things. I don't know, that means it's a good idea to commit your offences as a juvenile in Sark, or an extremely bad idea.
In the ordinary court and then
Yeah,
back in
yeah.
the magistrates, because I think they would probably be anxious about not breaching any rights of the young person. They've quite recently introduced most of the children law and things like that, and we have special arrangements. So they're becoming very sensitive about these things.
What seems sensible to me,
Yeah.
isn't it? Yeah. Okay. All right. Age, excuse me, obviously potentially an important consideration when we're looking at juveniles then. So as you can see, where a person is brought before the court and it seems he's not yet 18, the court should investigate, but there are no formal rules of evidence to apply to this exercise. So it's not like we're all going to start, looking at their teeth. I think that's one of the things that people apparently do. I don't know what that tells you, but apparently that's one way to try and determine age. Yeah, I mean, like get a birth certificate, it's not, a difficult thing to do, I would have thought. It should be fairly conclusive. But anyway, if it appears that the individual is not yet 18, they will be deemed to be a child, and the court will proceed accordingly. If they do find out the true age, as it says, anything that's already been done won't be invalidated unless they've passed a sentence that wasn't lawful to impose on an offender of the true age of the individual, in which case, obviously, they have to pass a legally valid sentence, which would mean setting aside the original one and doing something that was legally valid. 186, criminal responsibility, already talked about that, so that's like the bottom end of where age is a significant factor. 187, obviously time passes, life goes on, and it's possible to, particularly for someone that is been 17 for a while and is arrested and brought before the juvenile court, for them to actually have achieved their 18th birthday whilst the proceedings are still ongoing there. And so, as it says, if they have their 18th birthday before either the hearing where the mode of trial is determined or before they enter a plea to the charge, then that's it. There'll be a nice clean cut, if you like, or a clean break. They're no longer a child, and the matter should be removed to the magistrates' court. On the other hand, if they have their 18th birthday after we've gone through those stages, but before the proceedings have been concluded, then the court can continue to treat them as a child and deal with them in any way that they could have been dealt with if they were still under the age of 18. And that's fairly standard procedure, really. Appeals, as it says, the relevant provisions from the 1988 law we've already looked at in terms of appealing from the magistrates' court to the royal court will apply, as it says there, to the juvenile court as well. So appeals go to the royal court, and exactly the same points that we just looked at in terms of the test that's applied there, same proviso in terms of miscarriage of justice, or no miscarriage of justice, I should say. You can see then, last point really for this chapter, 189, possible for a child to appeal against a decision made by the tribunal or request another hearing in front of the tribunal once 3 months have elapsed. The appeal will be heard by the juvenile court, and the juvenile court's powers are to confirm, reverse, vary, or substitute a different decision for that of the tribunal, or remit the matter back to the tribunal, or do anything that the tribunal could have done. And that's chapter 1. And it's 12:05. So, 28 pages. Yeah, there is a lot in there. And I think, to be fair, at least some of the stuff in chapter 2 is repetitious or covers the same ground as some of the things. So, committal proceedings, that type of thing. So, we should be able to speed up a little bit. Now, obviously, it is 12:05. You are statutorily entitled to your lunch break. So I know in previous meetings, people have expressed enthusiasm for us kind of cracking on, but that's normally done on the basis of having an earlier finish. I'm not giving any guarantees that there'll be an earlier finish today, so you might want to take your break until 1 o'clock and then resume, so 55 minutes from now. Does that seem like a good idea now? I'm in your hands, guys. It's whatever you want to do. But all I'm saying is, if you say, no, let's skip the lunch break and just power on so we can finish early, I'm not convinced that we would finish early. So maybe you want your lunch break. Yeah.
Maybe we can start 15 minutes earlier. We're going to do it at some point anyway.
Yes.
And rather than just for the sake of waiting another 15 minutes to do
Yeah.
but I don't want to impose. I don't know what other people's plans are.
I don't think anyone's had particularly very live at the moment.
Well, you mean at this precise moment? Yeah. I'm sure you otherwise have thrilling lives, but not just now. Yeah, I'm happy with that. Yeah, we do that. Okay. Ben? Yeah, okay. Good. I don't know what you work on. Presumably you'd like to pop out and get a sandwich.
Yeah.
No, I'm fine, thank you. I don't really bother. With this.
Can I get yours?
Yeah, Karen. No, I'm fine, thank you, Kath. I should just continue with my H2O diet until I'm free. No, it's not. It's just stupid. But no, it's just easy. Really.
Can we get back in front of the building?
I think the building should be open. Yeah. All right. So were you? I thought I saw whatever her name was coming up the steps just as I was walking up.
Yeah, she was lovely. Where I'm going. And then there was no one here. And I thought,
No, they do seem to be quite keen on kind of, cutting it. I wouldn't say fine, but because I think I turned up here once. In fact, the first time I came over, I got my flight was on time. I was straight into the taxi. Taxi dropped me off outside. It actually dropped me off around the corner where there is another entrance.
Yes.
It's not used. And I was a bit confused by that.
Yeah. Well, I went down there as well.
Yeah. But then, came around here and I think, was it that day? That was a different day. But anyway, this wasn't open. They do tend to, okay, oh, so you're starting at whatever, 9, 10, whatever it has to be. We'll turn up at, 2, whatever the appointed hour is. They don't regard it as necessary. I mean, I think they would if you said, look, I need to be in an hour before to prepare everything. But, well, it's their work, isn't it? Why would they volunteer to start work any earlier than otherwise? But anyway. Yeah.
You're going to leave that thing?
Oh, no, I need to.
Yes.
You reckon you'll be able to turn it on again?
I mean, I can't really find anything. If I simply put stop record.